my lord, the opposite party verbal compelling to petition to retired my lord or notice given my lord. Therefore, the urgency tomorrow may be taken up the matter.
As secular or 2018, confirming judgment 2008 matter pending. The appellant got an interim order and created disturbance. Vacation pay.
No. Lordship, distinct judgment of Hon'Ble help or Lordship. Hon'Ble help or Lordship.
I don't know mention that. My lord, I don't know. RSA 311/12, my lord. My lord, opposite party hurriedly trying to demolish the structure.
Pardon to make a mention, my lord. My lord, WPC number 15048 to 2024. My lord, assigned bench is not functioning. My lord, the matter is urgent that on the 1st July 2024, the petitioner need to join that said course to pursue his fellowship program. My lord, urgency. So there is urgency. My lord.
So who is stopping you?
Matter may be listed.
Who is stopping you from joining?
The opposite party has not issued NOC, my lord, the secretary.
What is the urgency of that? You will get your NOC and you will join.
They have rejected, my lord, and 1st July is the last date to join.
I don't to mention, my lord, one bill, tied of bail matter next week in it.
My lord, after the collector in Anganwadi worker, my lord, 2021 matter. May I pray next week, my
Koyoban.
any day, lordship, next week, my
No, this is a heavy assignment. You know, a lot of matters are coming, so it will be very difficult.
One fresh admission matter of writ application of 2023 matter relating to disbursement of arrear salary of petitioner who was a GRS in the block.
How is it urgent?
My lord, from November 2022 till late, his salary is not disbursed.
No, you said arrear salary. What about the current salary?
Renewal also, the contractual period of renewalment is also not done.
So?
My lord, he is not getting any salary.
No, you want current salary or arrear salary? Arrear salary is not urgent. There's nothing urgent.
Arrear salary also is pending.
Don't think.
It's a fresh second order 41/2019.
Yes, that's all.
Which item number one?
One appeal.
I am on busy matter.
Year 2023. Suit for partition. I am the doctor here. For property of the Khasmar property. For that reason, suit has been dismissed. And appeal, it has been confirmed. The brother is in position. For that reason, suit has been dismissed.
What is the urgency?
Urgency is that the brother is going to sell away the property. That is the whole difficulty.
My lord, item 12 has been infructuous, my lord.
Item 12 dismissed as infructuous. Yes. Item 1.
My lord, I'm pardon, I am on busy, my lord. Item 1 may pay for next week, my lord.
Next week is paid for?
Obliged.
Item number 2.
Please, your lordship. This is a transfer petition. Your lordship, turn to page 41, your lordship. Page 41. This is another transfer filed by petition filed by the wife for transferring of a divorce case of the husband to family court Cuttack because here restitution case of the wife is pending. She is interested for reunion. Earlier, this honorable court sent for mediation as per the consent of the husband. But here the report in mediation he refused. Use page 41, your lordship.
So from Cuttack to Bhubaneswar, I am not allowing.
Cuttack to ये wife ये Cuttack ये तो he is interested तो mediation रे कोई दिल case सर ये
Cuttack to Bhubaneswar.
अच्छा दीदी टा case से ठीक अच्छी अच्छी restitution pending से तो पैसा दो cost देना जी
Cost कहीं दो Cuttack to Bhubaneswar भीतर किसी कर सकता
से
no boss चलिए virtually appear कर you don't have to appear every day. First of all, you don't have to appear every day in the court. You are only required to adduce evidence once or twice. That's all.
Family court तो each and every day lawyers are amicus curiae.
So what?
Family court.
So what?
So your lordship earlier in another case, your lordship in another case directed for mediation. Both parties appear and wife is interested for to stay with the husband and child.
No.
But
No.
without any fault, he is not interested for you.
You don't have to appear every day. You can appear virtually if you want. You can appear virtually.
Family court तो अपन तो ये है नहीं.
क्यों नहीं?
अपन तो अगर केस आसुनी लेट रे शो करने मुझे लेकर करियो कोर्ट से नहीं आएगी.
So let me find out whether the virtual facilities are.
भुवनेश्वर नहीं कटक virtual.
Bhubaneswar नहीं.
Family court नहीं.
I know of a person appearing before family court Bhubaneswar from Bangalore. What are you saying? I will.
If it will be facility will be available.
नहीं will कौन चिंता
Your lordship will observe.
The petitioner is the wife of opposite party number 1. She seeks transfer of CP number 757 of 2023 pending in the Court of Learned Judge Family Court 2, Bhubaneswar, to the Court of Learned Judge Family Court, Cuttack, on the ground that 2 other cases are pending at Cuttack. Further, she is a resident of Cuttack and has no means to travel to Bhubaneswar on the dates of posting of the case. Considering the grounds raised from this court does not find the same to be valid, so as to be persuaded to direct transfer of the proceedings. The transfer application stands dismissed. It shall be open to the petitioner to seek permission of the court to appear through virtual mode. Stop. Further, the setting. Yes.
But dispose of my dismissed.
Something dismissal jaha lekha house sir. Something dismissed lekha house. Kahara dispose of lekha. Upon you are a new practitioner or what? You are worried about that order of dismissal. Yes.
3. My lord, this is a transfer matter. The petitioner, wife of the petitioner, filed this case for transfer the case CP number 359/23 from Kendrapara to Bhubaneswar 2, Family Court 2.
All right. Take notice. Issue notice to the opposite party by speed post, fixing a short returnable date. Requisites be filed by tomorrow peremptorily. Peremptory. If you don't file, it will be dismissed automatically. If you don't file the requisites by tomorrow, it will be dismissed. Let's this matter on
18th July.
18 July. Yes.
Item number 4.
For me, Your Lordship, I am for the wife, my lord, shall seeking for transfer of the civil case matrimonial dispute from the judge family from the civil judge Rairangpur to the Court of Judge Family Court Bhubaneswar, my lord.
Well, I take notice. Issue notice by speed post, fixing a short returnable date. Requisites be filed by tomorrow peremptorily. List this matter on
18th July.
18 July.
I have a miss case, Your Lordship, matrimonial suit 63 of 2020.
Adjournment.
By Monday, if Your Lordship will permit me, because
Monday for what?
for filing of the requisites.
No, by tomorrow. Speed post man kali. 24 hours with the file karo.
May
Item kite?
Item 5.
Item 5. Yes.
May I please? It is a transfer case from Civil Judge Senior Division Bhanjanagar to Civil Judge Puri.
Is a matrimonial case?
Yes.
All right. Notice. You kar do. Notice with adjournment. Yes.
Item number 6.
Kali with the requisites. Requisites by tomorrow.
Yes.
May I please, Your Lordship? I am filing transfer petition for transfer the matrimonials from Baleshwar Learned Judge Family Court Baleshwar to Learned Judge Family Court Bhubaneswar, my lords.
Notice. Notice with adjournment.
Adjournment, Lordship. Great.
Item number 7.
My this case admittedly under wrong motion I have filed without checking the fresh circular of Anganwadi.
Appeal provision is there.
I can propose my letter. One thing may I submit that I have worked in that center only as Anganwadi worker for 6-7 years. If possible, my lord, is that period of service may be deducted from my present days to consider my case, my lord.
I didn't follow.
But I have worked there for 7 years.
Yes.
And now they have.
What are you challenging here?
I have filed this writ application thinking that the age is 40 years and I am going to be 39 years. So they have not considering my as a AC candidate, my application. This is all online application. They have not accepted. But after filing this, your lordships showed me that the new circular where is the age is only 35 years. So I am overaged. My only submission during this period, I have worked there for 7 years. In other recruitment service matter, where if you have worked some years in that organization, in that period of years will be deducted from the present age because I am age barred during working there. This is the principle. My learned senior knows it. If that can be possible.
Because it will amount to relaxation, my lord. So may I pray, my lord? The petitioner may approach before the authority with all these grievances so that the authority may consequence. And my lord, there was a direction to me to
No,
get
that's
the
right.
instruction with respect to the fact that whether this mini Anganwadi center has been upgraded in the meantime. My lord, I have got that instruction that it had not yet been operated.
Yes, who looks at the in order dated 2/5/2024, the order, the word depositing with an inverted comma occurring in paragraph 2 be corrected as depicting. Well, Land State Council has obtained instruction that the Anganwadi center in question has not been, the mini Anganwadi center in question has not been upgraded to a full-fledged Anganwadi center. Stop. Further, considering the limited grievance, the petitioner's case is that she was working as an Anganwadi helper,
Worker, my lord.
Anganwadi worker in the Anganwadi center
For the center.
Jampur.
Jampur.
in Jampur mini Anganwadi center since
My lord, I have,
my
my lord.
since 16 to 2010. Then you were disengaged.
Disengaged.
She was disengaged.
And that was pending before this honorable court. During, that was the interim order to continue and he was continuing. But during COVID, the advocate conducting the case passed away. So that is not within her knowledge.
Anyway.
On the date it was listed, it was dismissed. Thereafter, my lord, this press advertisement issued.
When were you disengaged?
When I have disengaged in 2015.
Correctly.
That I have not given.
She preferred an appeal, which came to be, she preferred an appeal before the collector cum district magistrate Balesur, which came to be dismissed on 8/4/2020.
2014. 20th February, my lord.
On
Judgment it was
22?
reflected 18.
22/2014. So what is this earlier date application? 8940.
Well, that is that when they have stated that I have filed an appeal and you have to appear, they have taken a plea, you have not appeared.
All right. So your appeal was again rejected.
Rejection.
Going to be rejected. 22/2014. The petitioner thereafter challenged the order of rejection before this court in WPC number 8940 of 2015. Said writ application was also dismissed by order dated 31/7/2023, passed by this court in WPC number 8940 of 2015. Ms. Mahapatra and counsel for the petitioner submits that in the meantime, the opposite party authorities having issued an advertisement for engagement of Anganwadi worker in the same mini Anganwadi center.
Yes.
She has approached this court. As in the meantime, she has become overaged. Stop. It is further submitted that the petitioner may be permitted to submit her candidature pursuant to the fresh advertisement, as I take it having regard to the fact that she was working as an Anganwadi worker since 2010. till 2015. Stop. This court observes that what the petitioner is essentially asking is for relaxation of the upper age limit for the candidates to appear, to submit their candidature. Stop. This is a matter to be decided by the concerned authorities. Stop. Therefore, without expressing any opinion on the merits of the claim advanced by the petitioner, the writ application is disposed of, granting liberty to the petitioner to approach collector. To approach
The selection committee chairman.
sub-collector, approach the sub-collector can take a decision. I don't think so.
Collector को साथ
Collector is not a party, but we can direct.
Yes.
Is directed to granted liberty to approach the collector, Baleswar, by submitting a representation within a week from today. Ventilating her grievances. Stop. If such representation is filed within the stipulated period, the collector shall consider the same in accordance with law and pass a reasoned order within 2 weeks thereafter.
Item number 8. Item 8. The Lordship had directed me to obtain instructions on the rationalization of pay of the non-teaching staff, computer programmer and all. But I have not got that. But your Lordship will kindly find from annexer.
Sir, just a minute. So what decision was taken by the government?
Yes, since 2011, they have said one thing, though I should have, as per your Lordship direction, I should have had the up-to-date instruction. But your Lordship will kindly find from annexer 12. Government had left it open for the university to decide at page 35.
Yes. But in spite of this, I think.
Yes, despite that, your Lordship had directed, but I am at fault. So I have sought for, but I have not got.
So they have referred to that rule also.
Yes.
Rule 21(1) of the Act under Rule 34 of the Odisha Universities, when it is considered by the Chancellor on the recommendation of the Vice Chancellor that it is necessary or expedient to do in the interest of the he may relax any of the provisions of the rules. So, but the government essentially has asked the university to pass the necessary order by relaxing the provisions. Why the university is sitting silent? Yes, Mr. Nath.
Sorry, my lord. The university, however, the finance is received from the government. The higher education department, with the chancellor, any post appointment or promotion or that also approval by chancellor. The chancellor, however, to the secretary to government. So that the government is necessary to any post appointment of plastic.
So now what will happen? The government says that the university is competent. University says that the government is competent. So this court will have to issue a mandamus then. Obviously.
Yes.
This court will issue a mandamus.
This will also direction to the government, also university. Okay, we have no objection, my lord. Nothing else. But the government approval is necessary, my lord.
After this letter, why the government approval is necessary? You can always refer to this letter. You can always refer that we had already submitted a proposal for rationalization of that two posts. Computer assistant or
computer programmer.
Programmer and assistant programmer.
Yes.
You have submitted that proposal. Now the government clearly says, in view of the above factual and legal position, if at all rationalization of pay scales of programmer is felt necessary, the Vice Chancellor with the approval of the Chancellor may take appropriate action. How clear is that? And this also applies to the Chancellor. I think
you also may direct disposing of.
No, we will dispose of directing the university to take a decision within a.
Which correspond to government.
Well. Government delegate the power. Government has delegated the power to you. What further?
Let a decision be taken at their level first.
What do you say, Mr. Mahapatra?
Madam, your lordship, kindly sorry, go to my counter, which I filed, the page 52, the last button.
Page 52.
52, my lord.
No. Yes.
That let, your lordship, my learned senior to said, that is annexed of page 35, that is dated 29/4/2011. 29/4/11. But my university, the register of university, said letter to Joint Secretary of Chancellor in 9/8/11, my lord.
Time and again it has been written, not that they are referring to only one particular letter. Several other letters have been written.
So that it is not a single case, my lord. However, that's the problem for the university. The university, any post appointment and any post promotion, that also university can do. So that I simplify your lordship. If the government is a part and parcel of the university, so that the financially also help the university and also problem will solve, my lord.
Yes, Mr. Mahapatra, what is your submission?
My submission, my lord. If you lordship go to.
Because the university has accepted your.
Not only once, but 10.
Yes, yes.
And time and again matter was recommended to by the registrar and the vice chancellor to the chancellor. Chancellor said, all right, you get the approval from the government. Government said, you are the competent, so you can take the decision. Thereafter, what I was saying, the letter, that is the letter of university. Again, the university only sought clarification from the chancellor. This is the view of the government, so kindly clear. Again, the chancellor said, no, you take the view of the government. Now, the government, thereafter, no decision has been taken. Again, comply with the government. Now, the matter is pending. The petitioner took retirement and matter of the year 2000, now in the 2024. And the person who is waiting for since 2000, now is not getting the pensions. And that too, you also kindly see the budget provision, what I was saying, that is also clear. That is the letter of the university, where it is very clear. Kindly see that letters. Where the university said the very nominal that can meet out of the page 25. Page 25. That is the university letter. The last line.
Yes.
The additional expenditure that is with connection to this, that rationalization, the letter for rationalization, the last line is the additional expenditure will be made out of the block grant received from the state government. So that is the view of the university.
So the problem is the university would have done it. The matter is actually the matter could not proceed because of inaction of the chancellor.
That is there. No, university
Is chancellor a party here?
Yes, yes. I think chancellor is a party.
Who is appearing for the chancellor?
Chancellor OP number 2.
Who is appearing?
Mainly chancellor by government.
Government.
No, government can chancellor by council. Mr. Udrata usually appears. OP number 3 and 4, Mr. Nath.
3 and 4 are also there.
What about the, so let us see. Learned additional government advocate for the opposite party number 1 and 2. 2 is chancellor. So you are appearing.
Who came the I think for 2 state government, state council cannot appear.
2 the state council appear. You have appeared for Mr. Nath, your Wakalat Rama. Please refer to your Wakalat.
I have appeared 3 and 4.
What about 2?
The separate counsel had appeared in another case. As your lordship said, Mr. Udgata is perhaps.
See, he usually appears for the chancellor. So there is some probably misunderstanding where you have been your name is indicated as a counsel for opposite party number 2 to 4, which is probably wrong.
2, 3, 4.
This was before Honorable Justice M.S. Sahu and also M.S. Raman. So the same thing has been. So accordingly, I have proceeded also. But the notice on chancellor probably has not been issued separately. What shall we do? Or we'll dispose of directing the chancellor to take a decision, sir?
Yes, boss.
Simple
That would be better.
That man taking that aspect and also the letter of the government and time and again recommendation of the.
All right, I'm passing the order. Please help me if I'm the petitioner has approached this court with the following prayer.
And you last time passed that order. Annex 15 has to be passed because that is without authority.
Which one?
Annex 15. Now the deputy registrar who has no authority, he said that they are not entitled. That's last time said that was passed. Only that is passed, nothing.
No,
Annex 15.
Yes.
He has no authority. He is the deputy registrar now.
No, but that runs contrary to the other communications.
Yes. That one admission of the register
The
and
petitioner has approached this court seeking with the following prayer. The case of the petitioner, briefly stated, is that being selected through a selection in a selection process, he was appointed as computer programmer by order dated 4/10/1996 of the registrar, Utkal University. He joined as such and continued to discharge duties till he was higher post को गले systems manager को गले 2004 रे
system manager को चार्ज देता से देखिए दाल पाइंदे से सीधे रिटायर कर गए.
अच्छा हो till his retirement on superannuation on
21 में सर रही.
since there was discrepancy with regard to the scale of pay of the petitioner as compared with his counterparts working in similar establishments, the petitioner submitted several representations to the authorities for rationalization of his pay scale. In particular, his request was to revise his pay scale from rupees 6,500 to 10,500 to rupees 7,300 hyphen 10,900. So it appears that his request was recommended by the university authorities to the chancellor on several occasions. Chancellor को से letter कहीं जो तो college government होगी. Where is that letter? Annex notice.
Annex 4 ta na kuda.
Several such communications are on record.
Yes.
By through a communication dated 27/11/2007, the Deputy Secretary to the Chancellor directed the registrar to move the government in Higher Education Department with adequate justification to obtain the concurrence of the Finance Department for the proposed rationalization of pay scale of programmer and program assistant in the computer center of the university. Accordingly, the government was moved appropriately. By letter dated 29/4/2011, the Commissioner cum Secretary to the government in Department of Higher Education informed the Vice Chancellor of the university referring to Rule 34 of the Orissa Universities, recruitment and promotion of non-teaching employees rules 1991, that it is within the power of the Chancellor to relax any provisions of the rules. As such, further, the following was observed. The last day, in view of the above factual in view of the above factual and legal position, if at all rationalization of pay scales of programmer, program assistant an assistant programmer is felt necessary, comma, the vice chancellor, with the approval of the chancellor, may take appropriate action as per the provisions of law, unquote. Yeah. The university authorities accordingly moved the chancellor by letter dated 9/8/2011. The office of the chancellor by letter dated 31/12/2011 held that, no, observed that the that Rule 34 is not applicable for rationalization of scale of pay, and accordingly requested for resubmission of the proposal of rationalization.
No. Reject.
While the matter stood thus, the assistant registrar in his letter dated 23/5/2012 replying to an application under the RTI Act held that, informed that under OURSP rules 2009, the scales of pay attached to the post of programmer, program assistant and assistant programmer is ₹9,300 to ₹34,800 and grade pay of ₹4,600, and further that that further rationalization of scale of pay does not arise. This court fails to understand as to how the assistant registrar assistant registrar could reject the claim for rationalization when the university authorities had been asked by the chancellor to resubmit the proposal for rationalization by letter dated 31/12/2011. There is no dispute that the proposal for rationalization was never resubmitted by the university authorities to the chancellor for consideration.
टिके भूल गला बोलते
कौन बोला?
टिके 31/5/12 जोड़ा अपन कहले टिके भूल कर देन होउछ
31/12/2011
हां 31/12 सेटा सेटा जी चांसलर जाई छी एटा चांसलर पठाई जा बना सेटा कहा
नहीं 31/12 देखंतु annexure 14 page 37 देखंतु
सीधा चांसलर पठेले आउ सरे किंता पूर्वटा ये पठेले सार देखंतु पूर्वटा रे
पठेले पर देखंतु
9/8/2011
हां हो ता परटा अपन देखो 31/12 कोन लिखले देयरफॉर यू आर रिक्वेस्टेड टू रीसबमिट द
पठेया पे हैं से कमेंट पठेया पे कहले
resubmit the proposal of rationalization of scale of हम कोन टू द गवर्नमेंट
गवर्नमेंट पठेया पे
से तो लिखु
मोल आपण चांसलर लिखले
नहीं चांसलर ये लिखले बोली
हां चांसलर लिखले मोल
कोन लिखले तो भूल जी तो सीट कोड
टिके भूल
For rationalization, when the university authorities have been asked by the chancellor to resubmit for proposal.
Resubmit the proposal for rationalization to the government.
By letter of effect 31/12/2011.
Huh.
There is no.
Cut off, cut off. There is, instead of. No, this court firstly observes that the government in higher education department in its letter dated set kind 35, no, letter dated 29/4/2011 had specifically observed that the question of the decision relating to rationalization of pay scales is to be taken by the Vice Chancellor with the approval of the Chancellor. In view of such clear observation of the Secretary to the government, there appears to be no reason to refer the matter to the government yet again. Stop. The matter appears to have been kept in suspended animation since then. Stop. In the meantime, more than 13 years have passed, and the concerned employee has retired on attaining the age of superannuation. Considering all the above facts, this court finds no justified reason to keep the writ application pending, which is therefore disposed of with direction to the opposite party number 3 to pass necessary orders for rationalization of pay scale of the post in question after obtaining necessary approval of the Chancellor as observed by the in view of the letter dated 29/4/2011 of the Commissioner cum Secretary to the government in Department of Higher Education. A decision in this regard shall be taken within a period of 3 months. Yes, Mr. Nath, any problem?
Sir, the page 56, that the register sent also letter to the Department of Higher Education. That order, that letter also mentioned.
Page 56.
Page 56, madam.
In the meantime, आपण reject कर देले तांगर. The question of rationalization does not arise.
But somehow the 24/9/12 we have sent a letter, madam.
57.
Yes, madam. Answer 56, madam.
2001 sir.
My counter, madam.
Sir, counter. Counter page कितने?
Page 56.
Page 56 is a no, आपण annexer कितने?
Annexer N/4.
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 Last page. Last.
It's last page now. See, ताको तो नहीं. कौन सी लिखने ऑर्डर?
अच्छा.
पुस्तक तो दें. हम दे जाओ.
अब ये चित्र ऑर्डर चिट्ठी दे दीजिए फोन.
ताको ताको नहीं बोलो सुने कि हम लोग ने कार्य नहीं.
ये चिट्ठी ऊपर ऐड कर करियो बन. ये जाई चाहिए ऊपर. अच्छा, so that has to be quashed then?
Yes. Then Annex 15 has to be passed.
Consequently, what is your prayer? Have you prayed for question of that?
No,
consequently, the letter dated 23/5/2012, copy enclosed as Annex 15, stands quashed. The writ application is disposed of accordingly. Within 3 months,
Item 9.
Let me put that.
My lord, last occasion, the state has taken time to take instructions as to what modalities has to be followed for
due recognition of ASA.
My lord, I contacted the authorities. This is a matter relating to 2013. There were guidelines with respect to the selection process. there are revised guidelines also relating to the selection process. With respect to the derecognition, my lord, I could collect the document which was issued in the year 2015.
How will it apply? You cannot have any retrospective application.
And thereafter, my lord, new guideline is also 2022 thereafter. For 16.
So what has happened in this case? She was appointed as
On that Human Rights Commission's order, my lord.
Oh.
The collector directed the CDMO to disengage the Asha.
There was a delay in that reaching of that delivery patients, yes,
causing new death of the new.
Let us see, let us see.
Here, Toko's notice issued. I have submitted my reply. They have.
No, let us see. You were initially warned or something like that.
Yes.
There was a warning or something like that.
Warning and I have been up.
Let us see, let us see. Kountu ଅଛି କଣ?
ସେଟା ହଉଛି annexure 3 page 10.
Yes.
Page 10. 11 କରିଛନ୍ତି.
ଗୋଟେ ଚେତାବନୀ ଦିଆଗଲା.
ଚେତାବନୀ ଦିଆଗଲା ଯେ.
Then
thereafter I was continuing while continuous. Collector has directed that in view of the OHRC case of such and such, the CDM was instructed to.
And I had asked you to produce the order of the that OHRC.
I have completed, my lord.
It
I have
was
submitted the same on 2/4/2024 along with the bunch of documents.
But no such order is there in the.
That is what I found.
No, it order no.
Disengage
No. To take disciplinary action.
He requested to cause necessary inquiry to submit a factual report to the commission. Where is the final order of the Human Rights Commission?
My lord, I have submitted a bunch of papers, my lord, on 2/4/2024.
Yes, I am seeing that.
My lord, there annexure 1.
One is that order?
Annexure 1 means, my lord.
See, annexure 1.
Sets, my lord.
I have got it.
Yes,
but where is that order?
11/2012, my lord.
Annexure 1 to no, annexure 2 is to. Annexure 2. So it's a Human Rights Commission gola. CORAM maji village hote na. Asha Didi told him there was no network. Demanded hote.
My lord, Lordship is referring to 17/10/2012 order, I think.
Yes.
No, final order. No, এটা তো 1710 ହେଲା. ମୁଁ final order ଯୋଉଥିରେ କହିଲେ ଯେ
27/11/2012.
2711?
2012.
Where is that order?
My lord, actually, I have prepared in 2 sets, my lord. Annexure 1 to Annexure 11. That is the documents which are in connection with this case. And some more documents which may be relevant. That is annexure in the same document set, my lord. Annexure 1 to Annexure 4.
Sir, then I would say the
Sir,
document.
the physical copy gote.
Physical copy ଅଛି?
ମୁଁ ଦେଇଥିଲି sir, physical copy.
ଗୋଟେ ସେଟ୍ ଗୋଟେ ସେଟ୍
ଦେଇଥିଲି?
ଏକାଠି ଦେଇଥିଲି ମତେ ବି ଦେଇଥିଲି।
ହଁ ମୁଁ ଦେଇଥିଲି ପରା sir। ମୋ ପାଖରେ
ଫାଇନାଲ ଅର୍ଡର ଯୋଉ ପାସ୍ ହେଇଛି ସେ ଆଉ ଗୋଟେ OHRC କେସ୍ ରହିବ। 27/11 ସେ ଆଉ ଗୋଟେ OHRC
27/11/2011।
ଏଇ ଯୋଉ 27/11/2011
ସେଟା ଆଉ ଗୋଟେ କେସ୍ ରେ ଅର୍ଡର ପାଇଛି 40,000 ଟଙ୍କା କମ୍ପେନସେସନ ହେଇଛି।
See, my lord, may come to the second page, my lord. The last but one para the ADMO FW has concluded in his inquiry that Asha Karmi did not go to the house of the patient at night, nor in the morning. She did not contact MO in charge or VPO with the Janani Express when Janani Express could not come in time. Thus, there was severe negligence in duty. Since negligence in providing medical care is admitted in the report, the commission hereby awards a compensation of ₹40,000 in favor of the patient, Jiradi Maji, wife of Goram Maji. The Chief District Medical Officer Kolahandi should also initiate necessary departmental proceeding regarding airing Asha for her lapse after giving her an opportunity of being heard.
So what the collector did after this?
After this, collector instructed the CDMO. CDMO issued me short notice. I have submitted. They warned and allowed me. File the matter to thus again the collector directed that to you.
So the initial show cause notice which you were just referring to, that was issued after this order.
After this order.
देखे
9/7/2013 Annexure 1 page 8.
কিন্তু এটা কোনো রেফার নাই, there is no reference to this order of the Human Rights Commission. ଆପଣ ଆପଣଙ୍କୁ ରିପ୍ଲାଏ ଦେଲେ, ତାପରେ
ରିପ୍ଲାଏ ଦେଲା ପରେ
ଭବିଷ୍ୟତରେ ଆଶା କର୍ମରେ
କରିକି
ଅବହେଳା ନ କରିବା ପାଇଁ ଚେତାବନୀ
ଚେତାବନୀ
ହେଲା।
Observation ରହିବା ପାଇଁ କୁହାଯାଏ।
ହଁ?
1 month ତାଙ୍କୁ observation
ହଁ,
ରଖିବା
ହଁ।
ପାଇଁ କୁହାଯାଏ।
ତାପରେ ହଠାତ୍ କଲେକ୍ଟର ଲିଖିଲେ ଯେ
କଲେକ୍ଟର ଲେଖିଲେ ଯେ to disengage her and collector
ଡବଲ ଜେପଡି ହେଇଯାଉନି, ଡବଲ ଜେପଡି ହେଇଯାଉନି। At that point of time, if you were acting in pursuance of this or the order of this Human Rights Commission, then you could have also
Yes.
taken action. You could have either estoppel or lagu hojibo. This is what you
I
say?
produced the entire records before lordship.
No, what is the law?
Well,
What law have you examined the law in this regard?
once he has been exerted and they allowed me, again on the self-same allegation, how they can disengage me thereafter. And our authority is CDM.
But collector is above the CDMO.
I'm-
Collector has directed the CDMO. Collector himself has not passed that order. You are requested to take steps for disengagement. So thereafter the CDMO straight away.
no, sequence of fact is like this, my lord. Collector directed the CDM to conduct an inquiry. CDM directed the ADMO to conduct an inquiry. ADMO conducted the inquiry, submitted the report before the CDMO, thereafter it was placed before the collector. Collector directed to disengage and disengagement was issued by the MO in charge.
No, where is that inquiry?
The series of documents, my lord, that is the document which are annexed in the set of documents.
Inquiry report is also in
Yes.
their counter, my lord. Annexed A/4. Inquiry is made on 19/10/2012.
So this is prior to the order passed by the Human Rights Commission.
19/10/2012.
That is what I'm saying. In the sequence of events, all that you are referring to has happened prior to passing of the order of the Human Rights Commission. So what happened thereafter? What happened thereafter is Annexure 1 was issued, show cause, even though it does not specifically refer to the order of the Human Rights Commission. Anyway, a show cause was issued. She submitted a reply and she was let off with a warning. Thereafter, the collector directs the concerned CDMO to initiate inquiry as per the order of the Human Rights Commission.
The decision of the CDMO is like this, my lord, which is Annexure 9 to my.
No, sir, you prepare a date chart. Prepare a date chart. One date chart will do, let the state council prepare a date chart. Because he has all the, Mr. Mahathi, he has all the documents with him.
Yes.
So let him prepare.
The date chart.
No, otherwise there will be, confusion. You get my point. You are referring to A/4. A/4 was, this inquiry was conducted prior to passing of the order of the Human Rights Commission.
Thereafter also, my lord, another inquiry.
Where is that inquiry? Already.
Prepare the date chart.
Yes.
For the purpose.
Date chart and refer to it.
Yes, sir.
Heard further arguments in part. Learned State Council is requested to prepare a comprehensive date chart for perusal of this court. Let's this matter next week. Next week.
That's your range.
Not both confusion habo. Yes.
Item number 10.
Oh. Item number 10. Yes.
These are the two judgments covers this case. I have already given him the copies in the past dates.
What is this matter, Mr. Das?
The
Professional
service was terminated.
Area block grant from 1/1/2004 to 4/8/2009.
1/1/2004, I may not trace that because none, that will be notional. And but this 100% block grant I am to get because other employees have received it from
1/4/2013.
Yes, 100%. That is, I have been page 15 may kindly receive. Page 15.
This is my judgment.
Yes, the first one. This is same identical issue. Following my lord judgment, thereafter another judgment of my court bench, Justice Satpathy.
If you,
that judgment.
sir, if you agree, I can dispose of in terms of this judgment.
Only, yes, ma'am. To the our counter is, my lord, on two faults. That is with respect to the first one and thereafter.
But he may not get because that will be notional only because that is
Now,
the decision.
Major thrust was actually given on the first one.
Then I verify.
Last
occasion I have also stated.
Telling that.
But kindly see page 15, my lord. That will the
Page 15 of
The writ petition, Annex 6.
Annex 3, copy of the approval order.
6.
6. Copy of 13 no 2013.
Again, kindly see, my lord, all of the employees 100%, 100%. To other 2% I don't know. I am at serial number 5. I am in the 60%.
Ravindra Kumar Varik 60%.
But as per the judgment of this honorable court, identical issue. My lord, same type of institution, same set of facts. They are also terminated, reinstated, because they have taken, you have not completed 8 years service from the date of reinstatement. That is not the law. You have been reinstated from the service. And the law is, the circular is the institution, not the person. So if the institution is getting 100%, I am to get the 100%, not 60%. This will be my prayer.
What do you say?
My lord, our submission is only with respect to that particular 100% block grant, my lord, with effect from 1/4/2013. That since he is to be considered as an approved staff with effect from 2009 prospectively with effect from that particular date. So on that account, my lord, we have disputed the first part, that first part of the prayer. Now it is no more. It is not. With respect to 1/4/2013, your lordship may apply that ratio.
No, see, first part of it, he is giving it.
Yes, but that is there in the order.
It is there in the order, and he is
Answer 4, Answer 4, 11.
page 17. Page 17.
Page 11.
Para 17. Para 17. After going through the provisions referred herein carefully, this court is unable to persuade itself to agree with the reasoning adopted by the opposite party authorities. From the scheme of the resolution, it is evident that the institution in question has to become first eligible to receive block grant. Once the institution comes within the granted fold, into column. All other employees are in receipt of 100% block grant except her, such assertion has been.
The government decision is at Answer 4, man. Well, listen.
Yes.
That is why I am not pressing the first part. I may not get it. That
Annex 4.
Page 11.
Page 11.
There they say that will be notional and they will not get the.
Annex 6 रे भी सेटा लिखा है.
So therefore, first part of my prayer will not be accepted.
Before disposing of, we can say that you are not facing that prayer.
No, notional to hobo because they are
Notional, not financial.
Financial benefit am पाइबे. That is in the view of this.
If you agree, then I can dispose of in light of this judgment.
Parvati Giri is a detailed judgment मेरा.
Parvati Ghode.
Parvati घोड़े मेरा.
आपने देखी तो ना थी?
दी थी मैं.
No, you आप.
Yes.
दी थी मैं.
Yes. Oh.
Consider को रिवील तो.
Consider financial because it is a financial.
Sir, consider को था कौन मेरा? Off the record, I'm asking you.
Your lordship may.
Off the record, I'm asking you. I'll simply say that
Your lordship may.
is covered by.
It's covered by that judgment.
Your lordship may.
Please assist me in dictating the order. The petitioner has approached this court seeking the following relief. The case of the petitioner, briefly stated, is that he was appointed as classical teacher in Satsang Shiksha Niketan, ENDRAI, as per order of the managing committee dated 25/6/1994. Stop. He joined in the post on 1/7/1990. He claims to have been illegally terminated by the managing committee, challenging which he approached the regional director of education, Bhubaneswar, in appeal number 112 of 2008. The appeal was allowed and he was directed to be reinstated in service. The petitioner, I see the petitioner, the service of the petitioner was approved by the Inspector of Schools, Baleswar, by order dated 26/4/2010. He was, however, paid block grant from the date of reinstatement in the school, that is, on 4/8/2009. The petitioner claims to be entitled to block grant from 1/4/2008.
1/1/2004.
1/1/2004. Sorry. Say लिखी दीजिए भूल हो गई
1/1/2004.
1/1/2004. Let us come to Annexure 6. By order dated 13/9/2013, as many as 10 employees of the school were granted block grant, with most of them being granted 100% GIA. The petitioner, whose name finds place at serial number 5, was granted 60% of block grant, with the period from 1/1/2004 to 3/8/2009 being approved notionally. ঠিক আছে?
নোশন ହେଇନି ଆଜି ସେଟା ଖାଲି ଫର୍ମାଲ ଅର୍ଡର ସେ କରିବେ କରିନାହାନ୍ତି ସେ ହବା କଥା
এই যে লেখা ହେଇଛି ତ କଣ?
ଆଜ୍ଞା
ଆଚ୍ଛା ହଉ। Alleging that, claiming that such non-payment of 100% block grant for the period from, I will say 1/1/2004, thereafter I will say from 1/1/2004 to 4/8/2009, as also differential block grant from 1/4/2013, the petitioner has approached this court in the present writ application. Counter affidavit has been filed by the state opposite party, by the district education officer, opposite party number 3. Inter alia, stating that as per the petitioner was in jail custody, for which he was terminated because of order passed by the appellate authority. He was reinstated. GIA was therefore paid, reckoning the date of his reinstatement.
Reckoning the date of approval. That has been treated as the date of approval.
ଆପଣ ମୁଁ ସେଟା କହୁଛି ରିଇନଷ୍ଟେଟମେଣ୍ଟ ହେଲା ଟୁ ତାପରେ ଆପଣ ସେଟା ଲିଖିଛନ୍ତି ଆପଣ ପ୍ୟାରରେ ଦେଖୁନାହାନ୍ତି।
ଠିକ
his such appointment was subsequently approved with effect from the date of his reinstatement. Stop. As such, he is not entitled to claim the benefit for the prior period, that is 1/4/2008 till 4/8/2009. ये तो ଏତିକି ତ କହିଛି ନା ଆଉ କଣ? Anything else?
ଆଉ ଗୋଟେ ଏଇ ଯୋଉ 2013
notional ଟା
ହଁ 2013 ଟା ପାଇଁ
ହଁ।
ଯେହେତୁ ସେ ତା ପୂର୍ବରୁ ରହୁନାହାନ୍ତି, 2009 ପୂର୍ବରୁ ସେ ରହୁନାହାନ୍ତି, so ତାଙ୍କୁ even notional ଟା ମଧ୍ୟ 1/1/2004 ବି ଦିଆଯାଇ ପାରିବ ନାହିଁ, because by that time he was not in service.
Further, his claim for payment of arrears
in terms of Annexure 6
from 1/1/2004 to 4/8/2009 cannot also be considered, as he was not in service at that time. Heard Sri Samir Kumar Das, learned counsel for the petitioner, and Sri S.N. Patnaik, learned AGA for the state. Sri Das submits that once the order of termination was set aside by the appellate authority and the petitioner was reinstated in service, his service is deemed to relate back to the period to the date of his illegal termination. Isn't so? That is what I was saying. Yes. That is why you are claiming.
yes that is the order also.
Further, the release of block grant or area grant in it, block grant chapter grant to the extent of only 60% from such date cannot be sustained as the same is discriminatory in view of the fact that the other employees of the institution and most of the employees, most of the employees of the institution have been granted 100%. Sri Das cites a judgment of this court passed in the case of Parvati Ghodai versus State of Orissa. Details. Yeah. Wherein, where is that relevant paragraph to refer to, Mr.
That is the matter quoted that one.
ये पैराग्राफ पर देखी दले ଆଉ କାହିଁକି ବେକାର କନସେଣ୍ଟ କରିବେ ସିଧା ଡିସ୍ପୋଜ ଅଫ କରିଦବା ଏଇ ଲାଇଟ୍ ରେ
Para 70.
ମୁଁ ସେଇ ପାରା ସବୁ କହୁଛି ମୁଁ ତ ସେୟା କହୁଛି wherein
But yes, that is I'm
ତାହେଲେ ଏଇ ପାର୍ଟଟା କିଛି କହିବାନି ଏ କିଛି କହିବାନି ଛାଡି ଦିଅନ୍ତୁ after hearing land counsel for the parties and on going through the judgment passed in Consta Parvati Ghodai Supra and Jashoda Giri Supra. Parvati Ghodai Supra followed in Jashoda Giri Supra. This court finds the case of the petitioner to be squarely covered by the ratio laid down the ratio of the said cases. The writ application is therefore disposed of, directing the authorities to consider the claim of the petitioner for payment of 100% GIA block grant, bracket block grant
with effect from 1
with effect from
1 for 2013.
1 for 2013, following the principles laid down in the above cited decisions. A decision in this regard shall be taken within a period of 2 months.
Yes.
From the date of production of certified copy of this order by the petitioner. Yes, Mr. Das?
yes.
Yes. Yeah.
Item 11. But inadvertently in speed post, I have filed it by registered post without downloaded Hinatla order status, more registered post. They tell it something.
The requisites filed be accepted and notice be issued as directed. Is this matter after service of notice?
Let's say for interim order is there.
Arjun.
Item 14. So I am appearing on behalf of Mr. S. B. Jana. Your Lordship, kindly see the last order of your Lordship.
9/5/2024.
9/5/2024.
My lord, this is with respect to that misplaced document from the office of BDO Kirmira to BO Kirmira, my lord. And the BO Kirmira was in additional charge, my lord, during that date. She had filed an affidavit. And on 9/5/2024, Lordship granted on the time, my lord, that as a last chance him to furnish necessary record and documents.
Order
9/5/2024, my lord. Before vacation, my lord, fixing the case today, my lord. So, I only pray, my lord, for next week, my lord. On information term. The correspondence actually Sokale filed. Further pursue. Next week, sir, positively will file.
Is this matter next week as well? The previous order be complied with positively.
And it is a Subarna Diba case could refer करके कैसा say ना बता सर dispose भी है जो.
Item 15. Item 15 I pray for a pass over, my lord.
Pass over.
Item 16.
And then Mr. Mahanti on his legs.
What will I do?
Pass over, my lord.
Pass over.
Item 17.
17, this will go to the appropriate bench. Let this matter before the appropriate bench with kind permission of the Chief Justice.
Item 18.
Appeal record test is. My lord, as per.
Last occasion, the law directed my learned senior to produce the records
Yes, my lord, the
listening to the selection.
different records have been provided to me and including the original appeal file also. Wherein the selection of both the period. There are two sets of selection process, my lord. One is in the year 2007 and another is in the 2018. Yes. The single appeal has been filed in the year 2019, my lord, that is against both the orders. And one appeal file has been prepared. And that in that appeal, my lord, both the selection proceedings are available. Though the original documents are, file is not with me, but the entire proceeding file of the selection, my lord, which has been referred to in the.
So that should be adequate? Please say much.
Here, my lord, I given the dates at Lakshmi Trial period. Last occasion it was filed. May I place the dates? An advertisement was issued on 8/5/2007, my lord, Annexure 1, page 12, for selection of Anganwadi worker of 6 Anganwadi centers, including Ramagoda 2 Anganwadi center, for which I am concerned, Ramagoda 2. On 11/5/2007, opposite party number 6, though belong to out of the center area, but she submitted her application in respect of this Ramagoda 2 Anganwadi center.
Who is appearing for opposite party?
On 21/5/2007, petitioner submitted her application with all documents and receipt was issued to that effect by the CDPO. That is Annexure 2, page 16, the receipt. On 23/5/2007, list of candidates was finalized, but it was not circulated publicly. In this list, the name of the petitioner was not found. That is at Annexure 3. On 6/6/2007, meeting of the selection committee was conducted and selection was conducted for all 6 Anganwadi centers. On 7/6/2007, opposite party number 6 was selected for the post of Anganwadi worker of Ramagoda 2, even if she doesn't belong to the center area, and the name of the petitioner was not taken into the zone of consideration. That is Annexure 5, the selection. On 20/10/2018, another advertisement was issued.
Why?
For selection of Anganwadi worker in respect of Ramagoda 1 Anganwadi center.
Okay.
On 30/8/2018, selection was conducted for Ramagoda 1 Anganwadi center. The opposite party number 5 was selected and the application of the petitioner was rejected since he doesn't belong to the center area. Thereafter, my lord, the present petitioner challenged the selection of the opposite party number 6, who has been selected for Ramagoda 2 center area, on the ground that she doesn't belong to the center area. So how she was selected? 2019, the appeal was filed, challenging the selection made in 2007. On 22/2019, after getting all the documents under RTI Act, appeal was filed by the petitioner with the petition for condonation of delay. On 11/7/2019, reply was filed by the CDPO Buguda, stating that the petitioner had not applied for Ramagoda 2 center area despite filing of the receipt. The receipt was available. So it was about that she has not applied for the center area. On 19/9/2019, a petition was filed by the petitioner in the appeal to direct the CDPO for production of the survey list of Ramagoda 1 and Ramagoda 2 center area. But that was not considered, and on 17/10/2019, the appeal was rejected by the concerned ATM. So here question is that, my lord, whether the opposite party number 6 belongs to the Ramagoda center area or not. That is
So before that, you have to satisfy the court that you were also an applicant.
the receipt is there, but they took a ground that a Xerox copy of the receipt was filed. But they never took a ground that that is a manufactured document or false document. Nowhere they have taken that ground.
Yes, Mr.
Either
Patna.
before the appellate court.
The ball is in your court.
Yes, well, actually,
whether she was an applicant or not.
Well,
Okay, let us go, for a moment, let us go to the impugned order.
Impugned order, my lord, at page 39.
And then there is a relevant portion.
Yeah, I'm placing. Page 39, your lordship kindly peruse. Paragraph 3, I am placing.
Yes.
The detailed report along with the copies of connected documents submitted by the CDPO Buguda revealed that a notice was floated by notification number 304 dated 8/5/2007 for appointment of Anganwadi worker in Ramagoda 2 Anganwadi Center. 4 candidates had applied for the said post and no application with the name of Tapaswini Ghade alias Das, that is the present petitioner, was received in this regard. Hence, the name of the appellant was not taken into consideration for appointment of Anganwadi worker of Ramagoda 2 Anganwadi Center area. The report further reveals that an advertisement was published for appointment of Anganwadi worker in Ramagoda 1 Anganwadi Center by the advertisement number such and such dated 2010-2018. After death of the incumbent Srimati Rangavati Pradhan, the appellant and 4 other candidates applied for the said post. Srimati Gitanjali Bholo, that is the opposite partner of 5 member, was selected and appointed as Anganwadi worker of Ramagoda 1 Center area. The applicant was not considered for the selection of Anganwadi worker in Ramagoda 1 Center area because she is not coming within the service area of Anganwadi Center. The CDPO Buguda has also filed connected documents to substantiate her report. Thereafter, well, this is next paragraph. In the above premises, it is observed that the appellant claims to have applied for the said post of Anganwadi worker of Ramagoda 2 Anganwadi Center in response to the advertisement published for the purpose by the advertisement number 304 dated 8/5/2007. But the appellant failed to submit any authentic documents to substantiate such claims. She has filed a photocopy of the acknowledgement receipt said to have been issued by CDPO Buguda on account of receipt of her application on 21/5/2007 for the post of Anganwadi worker. Neither the original document nor certified copy of the authenticated by government officer could be produced by the appellant before the court on demand. The photocopy of the document without any ink signed authentication by a competent government official cannot be relied upon in absence of original document, and when the authority of the public office is denying the fact, hence the photocopy is not taken into consideration. The appellant filed a petition on 19/9/2019 countering the it's not visible. The report of the CDPO Buguda, which appears to be an evasive presentation, no tangible or authentic materials come to the fore warranting consideration. The objection on the appointment of respondent number 4, Ranjita Kumari Sahu in Ramagoda 2 Center area, because of her residence in Ramagoda 1 Anganwadi Center area, is not sustainable, as the appellant have not produced any documentary evidence in support of her objections. So thereafter, the appeal was rejected.
Yes.
First of all, my lord, the selection was of the year 2007. And the appeal was filed in the year 2019. With respect to Ramgod 2. Now, my lord, the petitioner cannot simultaneously belong to Ramgod 2 and Ramgod 1.
It will be confined to only one.
Yes.
Now, my lord, her claim is that, my
So
lord,
far as limitation is concerned, the court has not considered that.
the ADM has
No,
not.
appeal has been
The
disposed
appeal
upon
has
merit.
Yes. Now,
That
my lord,
means he has condoned the delay.
yes. I am coming to that point of selection, my lord. So it was in the year 2007. Actually, my lord, I wrongly placed my lord that the original file is not with me, my lord. The selection file is also with me, 2007. 4 number of candidates they had applied. They have been issued with the receipts, acknowledgement receipts, along with the documents what they have submitted. The originals, 1 copy, the typed copy, 1 copy is also available in the file, and they have also the copy. But the petitioner, neither the petitioner's any single document of the petitioner is available in this particular file, nor any receipt to that effect that is available in the file. This is with respect to this Ramgod 2 minor in the year 2007, where proper procedure has been followed, objections have been issued, and thereafter, my lord, the selection has been completed. The proper procedure, the entire procedure, it is available in the selection file. Apart from that, my lord, there is also a single sheet document which is available for the different centers, my lord. Such type of center, my lord, that is, one is Golia, another is Colomba, Pochimundi, Bhomishali. There are different places and different Anganwadi workers. A single seat is there. The name of, in respect of Ramgod 2, the name of only those 4 persons. That is only available, and that was prepared in the year 2017. And accordingly, this selection procedure was completed, and the petitioner never objected. Now, that is with respect to the Ramgod 2, at the place where actually she resides. Now, she had never challenged this one, and our stand is that, my lord, that particular document is a photocopy of the document. And on the last occasion, my lord, it has been produced with the certified copy. The original certified copy has been produced before lordship. I found, my lord, the copy which is available in the record, the Xerox copy what she had produced, the certified copy of the same has been obtained, it has been produced before lordship.
सर्टिफिकेट कॉपी कोड आनले
ऑफिस एडीएम ऑफिस
किम जानले
रेकॉर्ड तार सर्टिफिकेट कॉपी टा
नहीं रेकॉर्ड कोटा को सर्टिफिकेट कॉपी से फाइल करे ताका एक्नॉलेजमेंट ता
से तांकर जोटा देइतले सब तांकर से जोटा देइचंती
सर्टिफिकेट ऑफ द एक्नॉलेजमेंट
से जो डॉक्यूमेंट ता देइचंती अनेक्स 2 रे भी सेटा भी तार ओरिजिनल ता से प्रोड्यूस करछंती
अगर से प्रोड्यूस करछंती दैट्स ऑल राइट
यस
बट अनलेस इट इज ऑफिशियली अवेलेबल हाउ कैन अ सर्टिफिकेट कॉपी बी ग्रांटेड
officially available means, my lord, that document has been produced before the authority, before the ADM at the time of appeal.
So at the time of appeal, no, I want the original file. सीधे के कुछ
say original file.
The original file नहीं कौन करा जो?
The entire file is.
Never they took a stand that the document which has produced.
Let them take a stand.
That is not a false.
No, let them not take a stand. This court has to be satisfied whether that document is available in the original file or not. This court finds that it is not there.
They have produced a survey list. Though the authority admitted that I have filed a petition to direct the CDPO to conduct.
No.
But that was no. Considered.
And you are making a contradictory plea. You belong to the you claim to have submitted your application. You are producing an acknowledgement slip which is not there in the original record. Secondly, you are challenging the selection of Hon'Ble worker for
last occasion I also submitted that for that prayer I am not present. In respect of Ramagod 1 because
dismiss
but they never produced this survey list.
No.
Another case also you also directed to the collector to conduct the survey and produce the list before this.
But there is a dispute, my lord. But in this
here it is palpably clear.
No.
It doesn't belong to the
court has to be privacy satisfied. That yes, what you are producing has a corresponding original in the original file. Here the original file, वो तो आप लोगों को ये तो कुछ फॉरवर्ड दे पाता नहीं। किंतु जो लंबा लिस्ट होची से लिस्ट है तो आप लोगों को ना
से लंबा लिस्ट है तापर हमें आउट टेबुलर लिस्ट
stand that this document the document which was produced by me is a false document or manufactured then
let there be no finding also with regard to the let there be no finding that it is a fraudulent or a fake document. But unless you are otherwise satisfy the court that yes, the document which you are producing before the court is also available in the original file, and the original file this court has produced. There is no such
original file is available with the CDPO.
Selected in this particular selection process. She is continuing for last 14 years.
And whether she belongs to the center area or not, that is the matter.
ଆପଣ ଯଦି applicant ନଥିବେ ଆପଣ challenge କରିପାରିବେନି. So that is the ଆପଣଙ୍କର କବାଟ ପାଖରେ ମୁଁ ଆପଣଙ୍କୁ ଅଟକେଇ ଦେଇଛି. ଆପଣ you cannot enter the room.
Only that, but no direction was issued. If your lordship will permit me, then I can sort of instruction whether the original is available. Because no direction was issued by
the
original.
ମୁଁ judgment of dismissal ସାଙ୍ଗେ ସାଙ୍ଗେ ଡାକୁଛି ଆପଣ ବ୍ୟସ୍ତ ହୁଅନ୍ତୁନି. ହବନି.
No, one chance may be given.
No, ଆଉ chance ନାହିଁ. No, Mr. Pandra, I have given you a lot of chance.
ମୁଁ ଆଜ୍ଞା ଚିଠିଟା ଦେଇଥିଲି ଯେ କିନ୍ତୁ କିଛି ରେସ୍ପନ୍ସ ଆସିନି.
ଆଜିକାଲି ଆଉ କିଏ ଚିଠି ଦଉଛନ୍ତି? ସବୁ ମୋବାଇଲରେ କାରବାର ଆଉ ଚିଠି କଣ?
ନାଇଁ ମୋବାଇଲ କଣ୍ଟାକ୍ଟ ନଉନଥିଲେ
ହବନି.
जो advocate ଦେଇଥିଲେ, he expired during COVID.
That's all right.
So thereafter,
In any case, you look at it. After 2 years, you are challenging the selection. The court has to be satisfied that you are an applicant. Unless you are applicant, you cannot challenge this selection. And that you have
my civic stand is that I am an applicant.
your specific stand is that you are an applicant, which has not been proved. This court finds no proof of your stand.
No,
Anyway.
for that reason, I am something that I may be giving a chance to produce whether there is a original document is available or not. For that reason.
But my lord, the document which has never been presented before the appellate authority.
No, he has presented now.
No,
Xerox was
he
presented.
submitted a photocopy of the
Oh,
document.
photocopy.
So the original document, neither he presented before the appellate authority nor before your lordships.
The CDP also not
Now he
stated
wants
that document is
to
a fraud
ascertain
document.
whether such an original document is available or not.
Let us one chance, lost. Because it's a bread and butter person and she's waiting since 2019.
Bread and butter. Kung? If she has not been an applicant, bread and butter. Kung?
Illegally.
No, bread and no butter.
Illegally.
No, neither bread nor butter. And you are trying to apply. You are trying to apply butter to a non-existent bread.
The last year can consider one person who has been selected illegally, she has been continuing.
Maybe. But the question of locus comes to the picture now.
Just for that reason, I am trying.
The question of locus, who can challenge it?
For that reason, I am trying to convince your lawsuit. I may be given an opportunity to verify whether original is.
All right. Sri S.N. Patnaik Learned AGA has produced the original file relating to selection of Anganwadi worker of Ramagoda 2. Perusal of the file reveals that only 4 applications were received and acknowledgement slips were issued to the applicants. What is this? The request kala pari right? Issued. There is no such acknowledgement slip showing receipt of any application from the petitioner. The Pondal and counsel for the petitioner requests for an adjournment to take instructions in this regard from his client. Please this matter next week.
Next 1 week after. More chithi more advocate expert the concerned advocate was handed over the brief.
Is this matter on 11 July?
Yes.
It is made clear that no further adjournment shall be granted.
Item 19.
अब आज ही पास ओवर नहीं. Let's this matter next week. पास ओवर तो next week कर दो हाँ. सेकंड पर आज मीटिंग है जो टाइम होगा नहीं मत.
Item number 20.
20 lordship opposite party number 4 has already entered appearance.
My lord, I am appearing.
Yes.
I am appearing for open number 4, my lord. Some time may be given to file my response because I have to produce certain documents through my counter affidavit. Some time may be given.
Counter has not yet been filed.
Counter has been filed?
No.
No, he requests for some time to file counter.
State has also not filed in counter.
Sashikanta Mishra Learned Counsel appearing for opposite party number
4, your lordship.
Opposite party number 4 requests for some time to file counter. The state, yes.
No counter has been filed, my lord.
The state also requests for time for such purpose. Is this matter?
11th July.
Out
25th July.
25th July, counter affidavit if any be filed in the meantime.
25th, my lord.
11th.
No. Okay. 24th row. Because 25th I will be absent, your lordship.
Virtually करिए.
ମୁଁ ତ ସେଇଦିନ ହିଁ ଯାଉଥିବି actually.
Virtually करिए कौन ଅଛି?
On that day I will fly, my lord. That is the reason.
May I prefer 11th?
पूर्व date करो.
24th. 24th, my lord.
Item 21.
May please. This is ready. Counter affidavit and everything has been filed.
Yes.
It is complete.
Yes. On the last occasion, I had filed one additional affidavit.
I have filed one additional affidavit, person who is the answer, my lord.
Yes.
They filed an answer to that. My lord, here is a case. My lord, may be permitted, my lord, your lordship may kindly take up 801420. of 2022. All three are similar matters, my lord. But 8014. Because the 8012 I have missed somewhere my different copies.
Yes, what is this matter about?
My lord, this is a matter relating to that my lord, disengagement of the Shiksha Swaya under annexure 13 to the writ application, my lord.
Yes.
My lord, here what has happened, the petitioner has passed the matriculation examination from Andhra University, my lord. My lord, he appeared in the examination, the petitioners appeared in the examination prior to 1988, my lord. But subsequently, because of some back papers, they subsequently appeared and cleared all the subjects. And thereafter, they were selected by the Director of Teachers Education to undergo CT training in Andhra Pradesh for the purpose of appointment of the petitioners in
mobile website.
Well, these people, they were selected by the Director of Teachers Education, Malad, to undergo city training in Malad, Andhra Pradesh to Malad, to be engaged in respect of the schools, Malad, bordering district schools, Malad, as Telugu teachers, Malad. Because your lordship knows, Malad, there are bilingual schools, Malad. They were selected and they underwent city training and they passed on. Malad, in the year 2003, my lord, your lordship will kindly have a glance at Annexure 4. Advertisement was issued for appointment of Swechhasevi Shiksha Sahayak on contractual basis, my lord. So, my lord, pursuant to this, I applied. All the petitioners, they applied, my lord, and they were selected. They were given engagement as Swechhasevi Shiksha Sahayak. Your lordship will find at Annexure 5, my lord, page 17. The engagement order. My lord, when this matter stood like this, my lord, suddenly the my lord, state government came up with another notification cancelling the earlier engagement orders, my lord, pursuant to the direction of this honorable court in the writ application, my lord, which I have stated in my application. My lord, there was a writ application filed by some people that there was no advertisement was properly published. So, my lord, this honorable court quashed the my lord, engagement orders or selection process in respect of the districts where it was not properly published, my lord. So, thereafter, Annexure 6 was issued. Of course, in Annexure 6, my lord, they said, my lord, the applicants which had already applied in the previous under the previous advertisement, they need not apply. They will be their cases will be considered along with the other candidates, my lord. So my candidature was also considered, and I was again, my lord, allowed to continue in the post, my lord. While my lord, surprisingly, my name was not published in the list. So I filed a writ application challenging that. While that writ application was pending, it, my lord, there was a assurance given by the authorities that if you withdraw the applications, my lord, will regularize your case. So, my lord, I bona fidely withdrew that writ application. That is the WPC number 1102 of 2005. My lord, after that, my lord, I'm sorry, that yes. After that, my lord, withdrawal of the writ application, instead of my lord, regularizing my case, my lord, they disengaged me under Annexure 13. Now I am challenging that, my lord. My lord, they have taken a plea that since you have passed the matriculation examination after 29/1988, as per the board's resolution, my lord, that the Andhra University matriculation will be treated as equivalent to the matriculation in relation to my lord board. Board of Secondary Education, my lord, till 29/1988. But fact remains that I had appeared for the first time prior to that date, my lord, all the petitioners, my lord. And subsequently, they cleared the other subjects, my lord. That is not in dispute, my lord. My lord, that is they have filed the counter affidavit. Their sole point is, my lord, they were not qualified because of the board's resolution and the instruction. That is, your lordship will find in their counter affidavit, they have filed that document. Annexure C/5 may be permitted to read.
Yes, please.
It is for the, this is issued by the Secretary, Board of Secondary Education. It is for the information that Annexure C/5 at page 10 of their counter affidavit.
Yes.
Lordship got it. It is for your information.
2022. 21/9/2022. Say counter. There are two counters.
These are counters.
There is additional affidavit to
No, sir, pratham counter counter affidavit. Subsequently, they have filed another.
Hey, that letter you are referring to is Annexure C/5. Is there some other letter?
No, C/5 in the original counter affidavit.
That is 11/2/2022. Is there a show cause notice?
No.
No. It is.
That is the counter affidavit filed in
1991 letter.
Sir, something nahi.
Their counter affidavit, they have filed the.
You are referring to 8014, sir? Petition number 8014.
Again.
Annexure C/5
is filed on 19/9/22. This counter affidavit was filed on 19/9/22.
I stand on 21/9/2022.
19/9/2022. Sir, 8/5 letter dated 6/12/2024. 2004. B/5 26/12/2024. C/5 letter dated 25/11/91.
That is what he is referring.
Yes, 25/11.
ସେଥିରେ କିନ୍ତୁ ଦେଖିଲା ବେଳକୁ ଅନ୍ୟ ଜିନିଷ ଅଛି।
ସେଟା ଟିକେ ପଢି
No, ସେଥିରେ ଅଲଗା ଜିନିଷ ଇଏ ହେଇଛି ଦେଲ ଫାଇଲଟା ଦେଲ।
They have supplied me this is the counter affidavit.
You are right. The headings show something, the document is something. Hard file ଦେଲ। इधर C/5 ଲେଖା ହେଇଛି 41 ଲେଖା ହେଇଛି କିନ୍ତୁ
it is letter number 2470.
ଟିକେ ଭୁଲ ସ୍କାନିଂ ହେଇଯାଇଥିବ କି କଣ ହେଇଥିବ।
ଆମର internal page 10.
ଏଇ ଦେଖନ୍ତୁ ଦିଟା C/5 ଅଛି। He has missed okay. Page 40 be C/5, page 41 be C/5. So that is the mistake. You have written. ଏଠି ବି Annexure C/5 लिखले। ଏଠି ବି Annexure C/5 लिखले। ସେଇଥିପାଇଁ ଭୁଲ ହେଇଯାଇଛି। Anyway. The previous page, for your information that the matriculation examination conducted by Andhra University was equivalent to the high school certificate.
Examination education Odisha till 29/1988, my lord. So, my lord, this is the reason for which they say that I am not qualified to be regularized in the post, my lord.
So you passed the matriculation examination after this?
After this, my lord, there is no controversy, my lord. My lord, I have filed one affidavit. My lord, pursuant to this, I have filed one affidavit, additional affidavit. Your lordship will find, my lord. That is filed on. Subsequent to that, yes. My lord, I have filed one additional affidavit. The lordship will find, my lord. Any issue.
I've got it.
Your lordship got it, my lord. Your lordship will find, my lord. There, we have appeared in the examination of the Andhra University. First, I appeared in the year, my lord, prior to that 1988. But there are some back papers, my lord, for which we appeared in subsequent years and cleared it, my lord. Now, if your lordship will kindly turn to, there another candidate exactly in the similar footing, my lord. That by name H, your lordship will find at page 9 of that additional affidavit, page annexure 15, page 9, my lord.
N. Hemosundar Rao.
Hemosundar Rao. he was also appointed, so of course, he was appointed basing on an advertisement in the year 2012, my lord. My lord, in his case, my lord, he has also passed the matriculation examination after this 1988, my lord. Therefore, what I say again, he was able to clear only 2 subjects out of 4. Later on rest, he has appeared and cleared on KV 1989, which was beyond the equivalent. As he has cleared the black papers after admissibility of the equivalent period, that's an easy clarification. They sought for a clarification from the board whether this candidate can be regularized or not. Then your lordship may kindly turn to page 16. Yes. Of course, what is their internal communication, I do not know. I could not find out but subsequently he has been regularized in service. One can presume, so it must be there in the company. Yes. To satisfy this. Now they have come up with a reply to my additional affidavit saying that in the year 2012, my lord, the qualification was +2, whereas in my in 2003 advertisement it was matriculation, my lord. Whatever be it, my lord, matriculation is the best examination, my lord. If he passes my humble submission before your lordship is, my lord, if he passes the matriculation examination within the time stipulated, then he will be qualified to appear in the +2 examination, my lord. Now he has passed the +2 examination. That is not a matter of consideration here because he has appeared in the matriculation examination. Subsequently, he has passed out after the cut-off date, my lord, and he has been now regularized, my lord. Why I will be discriminated not being regularized in service? All right. We'll continue next week. We'll continue next week. Heard in part. This is this matter. 4th July. You'll give your reply on that day.
Yes, sir.
And this will cover all the writ applications. Yes. All the writ applications. Same stand, same. All right. So since Mr. Mishra has completed, you will have to give a reply. That's all. Yes. So you will have to address the court on Article 14.
Yes, madam. In the additional affidavit, we had clarified that. Not in the similar
additional affidavit, they have said that +2, and here it was. No, it's not a question of +2. Yes. It's a question of acceptance of that particular degree or certificate.
Yes, madam.
That particular certificate. And if that be so, then what was the reason for seeking for a clarification from the board by in respect of that candidate? Or yes.
Item 22.
That's immediately urgent this matter.
Yes.
Urgent this matter.
Yes.
Urgent this matter.
Oh. I will go. When do you want?
1 month.
1 month?
Because my senior heart operation is recently done.
Correct. Therefore, adjournment is made on the ground of personal illness of the counsel for petitioner. List this matter. August ko nahi hai?
1st August.
1st August.
Item 23.
May I please, my
23 is not your matter.
May I please, my lords. In a transfer applications, my lord, the sole opposite party has notice is sufficient and ample time has been given to sole opposite party. He is not appeared, my lords.
All right. Despite repeated opportunities,
my lord, they are not.
There is no appearance on the side of the opposite party for which the transfer application is taken up for hearing. You want it to be transferred from?
From Khorda family court to Bhubaneswar. No, I'm my lords. That the girl is a housewife, my lords. His father is a regular wages carpenter. And second thing is, my lord, my kindly see, he is the Habildar in the Khorda police PS and threatening also to how can you come to the Khorda family court? That's why I'm paying for that region, my lords. And the girl is also staying 15 kilometers away from the Bhubaneswar towards Puri, my lords. A little child of 1.5 years, my lords. For that reason, I am coming.
The petitioner wife seeks transfer of CP number 159 of 2023 pending in the Court of Learned Judge Family Court Khorda to the Court of Learned Judge Family Court Bhubaneswar. The aforementioned case has been filed by the opposite party husband for divorce.
Pilot?
For divorce.
No.
How?
No. These filed, my lords.
Sir, ऐसे केस था डिवोर्स केस तो
Yes, my lord.
अच्छा तो बच्चा
Oh,
for divorce under section 13 of the
my lord.
Hindu Marriage Act. Therefore, transfer has been made on the ground that the petitioner is residing with her father
And with a little children.
and has a small child. It would therefore be inconvenient on her part to travel to Khorda on the dates of posting of the case. है ना? So, considering the submissions, to travel to Khorda on the dates of posting of the case, comma, I am inclined to allow the prayer for transfer. It is therefore directed that the proceeding in such and such shall be transferred.
Obliged, my lord.
Proceed for
Considering the fact that despite correct address, the opposite party avoided the notice on the last occasion, the lordship was pleased to direct the
IAC of the concerned police station, yes.
I've given a copy to
But
the
what happened, yes, State Council, in this case, notice was directed to be served through the IAC of the concerned police station.
on 16/5 I have given the copy.
23 or 24?
24. On 16/5 I have given the copy.
Me too.
Yes, my lord, it has been transmitted to the town police station, Keonjhar, my lord.
क्यों जो तो
Aye.
कौन है जी
Report that,
रिपोर्ट ऐसे नहीं नेक्स्ट वीक ऐसे हो कौन
next week, my lord.
नेक्स्ट वीक ऐसे हो नोटिस का सब
ଆପଣ ଆଗରୁ ଦେଇଥିଲେ ଯେ if a petition for time is filed, may I pray your lordship may say stay because ସିଏ ବାରିପଦା ପାଖରେ ହିଁ ରହୁଛନ୍ତି କେଉଁଝରରେ ଗୋଟେ
ହେଲା ଆର୍ଜୁନମେଣ୍ଟ ହେଲା ଆପଣଙ୍କ ଅସୁବିଧା କଣ ହଉଛି
ଆଜ୍ଞା
ଆର୍ଜୁନମେଣ୍ଟ ହଉଛି କେସ୍ ତ ହବନି ଶୁଣାଣି ହବନି
ଆଜ୍ଞା
then state council seeks time to inform the court regarding service of notice on the opposite party. Let's this matter next week.
4/7.
Yeah?
Next week, 4/7.
Actually, 4th July.
4th.
In the meantime, say adjournment order ta karta. Yes.
25.
And in this case, I need to communicate to submit on behalf of Mr. Behram.
Yes, please.
The petitioner is the wife of the opposite party.
Millard,
That's right.
small order dated 16/5/24. Wherein your lordship directed possibility of settlement. Wanted to take instruction. Millard. Submitted efforts have been made for amicable settlement of the dispute in the such matter. Yes, what happened?
No settlement.
Millard, the husband and wife are on several levels of disputes. So, if a conciliation can be held between them, either way the matter can be settled because the daughter has already been grown up. There is a very less chance of no. This court will always encourage settlement. Millard, mediation center को जाओ कौन पूछेंगे मिस्टर महापात्र previously थोड़े है थी ले mediation center जाओ High Court mediation center Millard in course of hearing it appears that the nature of the dispute is such as can be attempted to be resolved amicably through the process of mediation. In such view of the matter, let the records be placed before the coordinator Odisha High Court Mediation Center, who shall do the needful. The parties are directed to appear pursuant to notice received from the mediator and to render full cooperation in the mediation process. List this matter August.
8th August.
8th August. Interim order shall continue till then.
Item 26.
26, my lord, I was to take notice through police.
Yes.
That has not been effected. 1 week, a week's time be given so that
A copy already solved.
The State Council requests for some time to comply with the previous order. List this matter on
11th July.
11 July. The previous order be complied with positively.
27. Yes, Your Lordship, yesterday I filed the consolidated petition along with the IA Lordship for amendment of prayer portion, Lordship. Lordship, I am serving a copy on the opposite party, private.
Copy of the consolidated writ application be served upon Sri Mahathir and counsel appearing for the opposite party. And then the state also?
State I have served, Lordship. Receipt is there.
All right, all right. When do you want? List this matter.
Lordship, next week any day.
11 July. 11 July. List this matter on 11 July. Yes.
Item 28.
Well,
My pleasure, Lordship. Last occasion, your Lordship has instructions to reconcile the previous order.
कौन है जी? Previous order be complied with positively. What is this? अच्छा. You were directed to take instruction whether the father of the petitioner belongs to scheduled tribe or not.
Short, but it has not come.
Orders are not being complied with.
No, because of
This order was passed on in November 2023, Mr.
that
Das.
should not have, but because of the intervening elections, there have been some disturbance.
November election April कौन खोज नहीं?
For these days, last month and
No. This is not acceptable at all.
let me see if that.
I'll grant you 3 days time. November pass रहेंगे.
Sir,
Land State Council seeks time to comply with the previous order. This court is ordinarily not inclined to allow further time, since the direction was issued way back in November 2023. However, as a last chance, 1 week time is allowed to the petitioner, to the State Council. Stop. List this matter next week. The previous order be complied with positively. Yes. Spelling which appropriate order shall be passed.
Oblige me.
Item 29.
Please. My lord, the petition is the wife of opposite party seeking transfer from the Court of Law Judge Family Court Travancore to Court of Judge Family Court Jaipur.
What is the office note? Notice written undelivered from sole opposite party with postal report address left without instruction. Congratulations. You have to take notice again. Yeah, through police. Let a copy of the
29.
transfer application be served upon Land State Council by tomorrow. Who shall cause the same to be served upon the opposite party through the IAC of the jurisdictional police station, indicating that the matter shall be taken up for hearing on
18th July.
18 July. List this matter on 18 July.
Item number 30.
Yes, item 30.
Time for the opposite party.
None appears for the petitioner on repeated calls. List this matter next week.
Item 31.
Opposite party husband is not found. No such person in this address.
Same police notice नियंतु.
से दी address देखे जो गोटे तार निजर गाँव होची गंजाम ना प्रेजेंट रिसाइडिंग भुवनेश्वर.
Who shall cause the same? Let 2 copies. Let 2 copies of the transfer application be served upon State Council by tomorrow. Who shall attempt? Who shall cause the same to be served to the concerned police stations,
Lordship.
indicating that the matter shall be taken up for hearing on
18th July.
18 July. List this matter on
Content, Lordship.
Yes.
Item 32. We have Mr. Sayo kindly be taken up next week.
Next week, habo.
11th July.
List this matter on 11 July. As per
Interim order to continue.
interim order to continue.
Item 33.
May I please, Your Lordship? Your Lordship may kindly see the last order.
notice was sufficient, but none had appeared. Your lordship has granted one opportunity on last occasion. Today also none has appeared, my lords. Because this is a case wherein we are.
We'll take it up.
My lords.
We'll take up.
My lords.
None appears for the counsel for the petitioner is present. There's no appearance from the opposite party.
Husband, my lords.
On the last occasion also, there was no appearance from his side. But in order to grant an opportunity, the matter was adjourned to today. Since there is no appearance today also, the transfer application is taken up for hearing. Yes.
This is a matter wherein we are seeking to transfer the matrimonial suit number 281 of 23 from senior civil judge Rairangpur to learned family court family judge in Bolangir, Milos. I am presently, my workstation is at Baling. I am an assistant professor working in pharmacology in Bhima Bhoi Medical College.
Bhima Bhoi
Medical.
Bhima Bhoi. When you pronounce, you may say in English, but the proper noun has to be pronounced as it is.
I may be pardoned for that.
No, you don't have to be pardoned. Yes.
But
on what ground?
On the ground that it no direct communication whether by train or by bus, and it is the distance of 430 kilometers, and I have a 10-year-old son, Milots. So whom I have to take
The
care.
petitioner is the wife of opposite party and seeks transfer of mat suit number 281 of 2023 pending in the court of learned senior civil judge Rairangpur to the court of learned judge family court Bolangir. Prayer for transfer has been made on the ground that the petitioner is presently working as assistant professor in the Department of Pharmacology in Bhima Bhoi Medical College and Hospital, Bolangir. As such, it would be difficult on her part. And just further, Bolangir is at a distance of more than 400 kilometers from Rairangpur. She also has a 10-year-old child. For all the above reasons, it is submitted that it would be highly inconvenient on her part to travel to Bolangir to attend the court on the dates of posting of the case. Considering the submission as above and the ground cited for transfer, this court is inclined to allow the same. The transfer application is disposed of, directing you let the records such and such be transferred. Yes.
Item
Formal order of 34.
My lord, on behalf of Mr. Vrindavan Raut, I pray for an adjournment, my lord.
Place this matter on
Next week, any date, 11 July.
11 July as per.
Much obliged. Item 35.
Item 35, my lord, inadvertently, my lord, as per the noting, IE number has been wrongly typed, my lord, instead of 6574.
The order will be corrected accordingly.
My lord.
Correction
Item 36.
Okay, nothing. 36.
May I plead, Lord? My lord, here the petitioner is in custody since 29/2021, my lord. And earlier the present petitioner had approached before this honorable court by BLAPL number 7259 of 2022. That is under Annex 2, my lord. They have given. And it was withdrawn, and this honorable court has given liberty to move after examination of Bonita Das,
Bhaino Das, Ranjana Das, and Sunita Das.
Sunita Das. And out of 3 witnesses, my lord, Boina Das and Ranjana Das have already examined. And
What about Sunita?
Sunita, he is summoned since last, my lord, 29/11/2023. Till that, she was not turning up, my lord. And last occasion, my lord had called for a report from the learned trial court. That was flag X, my lord.
The court below has submitted a report stating that the charge sheet witness number 2, Sunita Das, has not been examined as yet. So, what have the other witnesses said?
Well, they are not supporting the prosecution case. I am supporting the copy of the report. Then the blue one is my lord, Boynath Das, my lord. In cross examination, I am not examined by the police in connection with the case.
ସେ ତ କହିନାହାନ୍ତି କିଛି ରଞ୍ଜନ ଦାସ ରଞ୍ଜନ ଦାସ ନା ରଞ୍ଜନ ନା ଦାସ ଦି ଜଣଙ୍କ
Hostile.
hostile. What about the Sunita Das?
Sunita Das was not
Examining ସେ କଣ କହିଛନ୍ତି?
ସେଟା CD ତ ଆସିନି, only the deposition copy has filed.
The call for the
call for earlier.
CD ଟା ଆଣନ୍ତୁ
Right.
CD ଟା ଆସୁ ଦେଖି କର up to date case diary be obtained and ଆଉ in the meantime କାଳେ examined ହେଇଯିବ ଏବେ hostile ଏବେ ଜଣା ପଡି ଯାଉଛି
Since 2023, she was not turning up, my lord. I am supplying the copy, my lord. Someone
ଦରକାର ନାହିଁ ଦେଇଦି up to date case diary be obtained latest matter 10 ଦିନ ପରେ 11 July.
Item 37.
I would like to go through the statement of Sunita Das. Yes.
May I please question?
कितना अच्छी total? हैं? All right. Sir, yes, Mr. Banti.
85% permanent disability person is in custody lordship since 28/8/2023. Allegation of
Rahul Mishra.
NDPS Act, 54 kg of ganja. So when the excise personnel were performing the patrolling duty, they found one vehicle was coming and detained the vehicle. The passenger.
You were escorting.
He is escorting. The allegation was escorting.
So same order Vichitra Behra.
Vichitra Behra, this is pending, madam.
So Vichitra Behra disposal.
That is not allowed.
I've granted bail.
Similar footing.
Same order.
Perhaps order was not uploaded.
What's in it? Upload history.
10648 of 23.
10648. All right, same order.
Item 38.
Suraj Dali alias Babu. Who?
Hey, similar. And here, it's not been implicated initially under P02 by 34 FC. Subsequently, charge sheet was filed under section 302 34 120 P07 IP7. Allegation against unknown FIR number. Here, external languishing in the jail post from 21/10/2022. There might not CD SCO, but the statement of the one eyewitness is Rajesh Pradhan. And you lost his statement, other persons has been released. And I have
granted bail to one Sagar Sahu. Let him obtain the case date.
4% have been released on bail.
But he is not coming under similar case.
Let us obtain the case date. Up to that case date, we obtain latest matter on
11th July.
11 July.
Item 39.
Yes, Miss Behra.
May I please, my lordship? My lordship, this is the bail application.
Deposition copies.
Deposition copy already have submitted, and another witness number 10.
Rakesh Samal. Acha ho. The case of murder.
My lordship.
Earlier rejected.
My lordship.
You were directed to examine Prakash Swai, Satyanarayana Swai, and Lakshmana Pallai. These three have been examined.
My lord.
Kon କହିଛନ୍ତି?
PW1, 3 and 4. Satyanarayana Swai is PW1, my lord.
ଦିଅନ୍ତୁ
Already have submitted, my lordship.
ଦେଇଛନ୍ତି ଏବେ
PW3, PW4. These are the eyewitness, my lordship.
ଦଉନାହାନ୍ତି ଆଜ୍ଞା କପିଟା ଦିଅନ୍ତୁ
My lord.
ସେଟା ପୁରା ତାଙ୍କ ଏଗେନଷ୍ଟ ଅଛି ସେଇଥିପାଇଁ ଦଉନାହାନ୍ତି ନାଁ କଣ ତାଙ୍କର
PW1, my lord.
ପ୍ରକାଶ ସ୍ୱାଇଁ ସତ୍ୟନାରାୟଣ ସ୍ୱାଇଁ ସତ୍ୟନାରାୟଣ ସ୍ୱାଇଁ କହିଲେ died on ଏତେ having been killed by my present accused. At the time I was going to play cricket. At the time I found that Rakesh Samal and Rakesh were assaulting Pratap. So he's an eyewitness.
Eyewitness.
PW3 is also matter. Lakshmana Polite.
The accused Rakesh Samal was then holding Katti. Bracket से तब clarify करें कुकुड़ा कट्टा Katti. And his younger brother Raja Samal was holding a churi. Kukuda kota churi. ये भी कोई चिंती.
Then my lord PW4.
से भी सही कुकुड़ा कटा छुरी.
Same.
My lord, sir, this belongs to totally political because
yes, political, huh?
BJD party.
तमरा political model है ले बेली रो रहता ना
My lord, sir, the thing is that when he was 13 years old, this person, 4 persons, they went inside the house and in front of the house only, they have murdered his father. And 3 were arrested. And this one was he was
तो
absconded.
बदला लेने के लिए वो आ गया.
With anger only. He has also confessed that because in 13 years old, he has seen his father.
Already I have rejected your bail application once and I have also granted you interim bail.
Yes,
Be
ma'am.
satisfied with it.
Him also, and he has also surrendered, my lord, sir.
Be satisfied with it.
So, my lordship, kindly be granted interim bail, my lordship.
No clear direct
Because,
evidence ଅଛି.
Because interim bail.
Sorry. The petitioner is in custody since 18/7/2021 in connection with such and such case. His earlier application for bail was rejected, granting him liberty to renew his prayer after examination of some eyewitnesses. In the meantime, several witnesses have been examined, including Prakash Swai, Satyanarayana Swai, and Lakshmana Polai. From the copies of the depositions of said witnesses, it is seen that all 3 being eyewitnesses have directly implicated the petitioner as having fatally assaulted the deceased. Since a strong prima facie case exists against the petitioner, I am not inclined to allow the prayer for bail, which is therefore rejected.
Item 40.
Yes, item 40. So, call it, pass on.
Item 41.
And on the PS5 and transfer.
Possible, my lord. Your lordship called for the condition of the health condition of the petitioner from the jail authority.
Yeah, let him come.
What?
No, you want adjournment?
One day. It has not come, so tomorrow or Monday.
As requested by London State Council, is this
Monday.
matter next week?
Next week. Yes. Positively, it will come.
Petition.
ଦେଇଥିଲେ interim bail ମାସେ ଦେଇଥିଲେ surrender କରି
Acha, on Monday. We'll take it up on Monday.
ଏଥିରେ 10-12 ଜଣ accused ଅଛନ୍ତି.
ଗୋଟେ ଦିନ
But,
ନେଇ ଆସିବେ ହେଇଯାନ୍ତା
Superintendent sir,
Monday.
accused ଅଛନ୍ତି ସମସ୍ତେ ସେଇ interim ପକେଇଛନ୍ତି. ସମସ୍ତେ.
କାଲିକି
Everyone.
ପ୍ରେୟାର କରୁଛୁ କାଲିକି ରହୁ ଯଦି ନେଇ ଆସିବ
Monday.
Monday, man.
Yes,
Monday.
item 42.
Yes, 42.
Please, your lordship. But I am there virtually.
Yes.
Lords, this is that bail matter, my lords, wherein BLAPL 6216 your lordship has restored in the CRLMA, and thereafter I have moved this BLAPL 5062 of 2022.
And that BLAPL number was not listed.
It is listed. It's listed in today's list.
Yeah, it's been again
216.
It was dismissed again for non-prosecution. थरे होइतला, restore ହେଲା, ଆଉ ଥରେ ହେଲା. 1/12/2023. But unnecessarily, why it should be kept pending? I don't understand. So this CRLMA तो file hindi?
CRLMA तो ଗୋଟେ ହେଇଥିଲା 364.
So that's why it was restored. Again, it has been dismissed for non-prosecution. So it is no longer there. It's a disposed of case. Isn't it?
Mine.
Yes. What about the CRLMC?
CRLMC, I have challenged the order framing charge if your lordship will remember, my lord issued notice and granted stay of trial. But since the trial did not commence at all, I filed an IME lords, and your lordship vacated the interim orders of stay on 14/5.
Yes. I remember. Yes.
In the CRLMC, the entire trial court records are there, my lords.
So that is what it was called for. Now what happened? They placed the bail application?
My lords?
I think you can hear the bail application now.
Yes, my lords. Here the FIR is dated 20th of September 2021, my lords.
Yes.
And as per the FIR, my lords, the STF got some information about accused persons dealing with narcotics, my lords, and getting that information made a station diary entry and proceeded to the spot, which is, my lords, the Tangi, my lords, National Highway near Tangi, my lords.
Yes.
There they saw one person was waiting with a bag, my lords, and he was identified by the source. If my lords may look at page 11 of the brief.
So he is the supplier.
He's the supplier. Both the present petitioner and his brother is also engaged in this case.
The only thing is that they belong to West Bengal. That is why I had rejected. How किसी नहीं. Confessional statement रे हिची normally आप किसी असुविधा नहीं किंतु but the problem is they are West Bengal. Yes, what do you say?
And this is that he is the outsider, and this present petitioner and his brother both were engaged. They are supplier. And
No, but this is on confessional statement.
confessional statement.
Case is not made out of the rule.
And the FIR was registered on 21/10/2021, and present petitioner was arrested on 7/1/2020.
The problem is once he is released, he will go away. He will never come back. That is the problem. The trial will
Your
remain.
lordship can say that I will stay and complete the trial. Trial is not being held. And your lordship doesn't want to release me. Then what I am undone, my lords.
No, I understand your predicament, but the question is how to guarantee his presence during trial. That is the sole thing that the court will be.
Lords, if your lordship will direct that I will stay at Cuttack and report at the Lalbagh PS once in a week, I think that will be sufficient.
No, but if he violates again, if he violates that, MBWI will be issued and he will go to West Bengal. That is the problem. Otherwise, I think it's a very good case because this is a confessional statement. Whatever may be the quantity of contraband, but the question is it's a confessional statement.
Pure confession.
Pure, say लिख ले पड़ा. Sheikh Khokon confessed that he used to carry brown sugar business since 15 years and he is addict and used to procure the same from Lalu.
My God.
Whether this was also procured, he doesn't say so. He used to procure. All right. The petitioner is in custody since
8th of January 2022.
8th of January 2023.
22.
22, my lords.
8/1/2022 in connection with such and such case. The prosecution case is that one Safikul SK alias Khokon was apprehended by the STF personnel and on search 1 kg 43 grams of brown sugar was found from his possession. On interrogation, he confessed of carrying out brown sugar business for the past 15 years. And further that, he used to procure the same from the present petitioners. The Devasis Panda, learned counsel for the petitioner, submits that apart from the fact that the petitioner's implication is on the basis of a confessional statement of the co-accused, fact remains that there is even no evidence that the contraband seized from the co-accused had been supplied by the petitioners. Petitioners को दूसरे हैं ना? Petitioners.
ଗୋଟିଏ ପିଟିସନର
ଜଣେ ଅଛି ପିଟିସନ
ଏତେଲେ petitioner. अच्छा. ଗୋଟେ କରିଦବୁ ଦେଲେ ହେଲା ସେ ଲାଲୁ ଆଉ Sri S.K. Mishra, Learned State Counsel, opposes the prayer for bail by submitting that the quantity of contraband seized is huge. Stop. Having regard to the rival submissions and on going through the materials on record, this court finds that the only basis of implication of the petitioner is the confessional statement of the co-accused. There is no other independent evidence showing his complicity in the alleged occurrence. Under such circumstances, in such view of the matter, the ratio of
2021 volume 4 SCC page 1.
Tofan Singh, the ratio laid down in Tofan Singh versus so and so, is squarely applicable. For the foregoing, in the result, the writ of bail application is allowed. Let the petitioner be released on such and such conditions, including the following conditions. 1, he shall appear before the IAC of କୋଉ ଥାନା କରିବା? STF.
ନାଇଁ STF କରନ୍ତୁନି ଲାଲବାଗ PS ପାଖରେ let him appear.
Okay. IAC of Lalbagh police station on every Sunday at 10 a.m. We'll say till conclusion of trial.
Let
Yes.
it be every Tuesday.
Okay, all right, every Tuesday till conclusion of trial. And such facts shall be certified by the IAC to the concerned court once in a month.
And his mobile number,
No.
live location, yes.
Further, he shall not leave the territorial jurisdiction of the court without obtaining leave. He shall furnish his contact address. दरकार नहीं तथा लिखी
And outside the live
furnish
location.
his contact address and telephone/mobile number to the court as well as the IO at the time of his release.
ଆଇଓ କୁ କୋଉଠି ମୁଁ ଯାଇ ଖୋଜିବି କୋର୍ଟରେ ମୁଁ ଦେବି ସବୁ ଆଇଓ କଥା ମତେ କୁହନ୍ତୁ
କୋର୍ଟ ଯେତେବେଳେ କହିଲେ ଟିକେ ଆକ୍ସେପ୍ଟ କରନ୍ତୁ
ସେ ଲାଲବାଗରେ ଲେଟ୍ ମି ଫର୍ନିଶ ଏଭରିଥିଂ
ସେ କଥା କୁହନ୍ତୁ ଆଜ୍ଞା ସେ କଥା କୁହନ୍ତୁ you will furnish it before the IAC କିଛି କରିବନି କହିଲେ କେମିତି ହବ ଆଜ୍ଞା let the court pass that order
ମୁଁ କହୁନି କିଛି କରିବି
ନାଇଁ ନାଇଁ ସେମିତି କହିଲେ ହବନି ଆଜ୍ଞା
ଓନର ସେ STF କୁ
ଠିକ ଅଛି I'll modify it to the IAC I'll modify it to the IAC ଆପଣ କରିବେନି ବୋଲି କହିଲେ କେମିତି ହବ ନାଇଁ ଆଜ୍ଞା ବିରୋଧ IAC କରିଦିଅନ୍ତୁ ଓନର ଶୁଣୁଛି ଯଦି ଆପଣ କହିଲେ I will modify it I have modified it CRLMC before the assigned bench. Yes.
Item 43.
Lord, may I pray for an urgent copy of the order?
Yes, urgent copy of this order be done properly. After you could have whatever 5 seconds. Chalo.
May pardon me. Item 30. Non-appearance age ଟିକେ ଆଉ ଟିକେ କୋଟେ ରହିଗଲେ
ଖାଲି next week କରିଦିଅ non-appearance ଟା କାଟିଦିଅ
interim dash or interim dash
interim order to continue
15 ଟା pass over ହେଇଥିଲା next week
15 next week
16 we are yet to receive the counter from the state. So after
item 15
16
item 16
they are connected matters, similar matters.
change 11 July
16 my name does not reflect in the 16 item.
the name of Sri Sashikanta Mishra be reflected in the corpus
Item 16.
15 interim order ଅଛି your lord
16
interim order continue ଯୋଉଥିରେ ଅଛି interim order ଦେଖି ଦେଇ କରିଦେବୁ
33 minor and 1 week
33 1 week after सरला ताले पास ओवर सरला
33 ଟା ତ ହେଇଯାଇଛି
ହେଇଯାଇଛି
33 ଟା ତ allow
weekly check up ହେଇନି
Petitioner, my lord. Found in possession of some 2 quintals
from the spot. Date of FIR is, my lord, 7/10/2021. Charge sheet has been filed on 2/4/2022. 3 persons were in the auto, my lord, from which, my lord, the contraband article was seized. In that case, my lord, one of the co-accused, he has already been released from bail because due to long pretrial detention, my lord. Regular bail. ଆଜ୍ଞା କପି ଦଉନ ଦେଇଥିଲେ ଏପର୍ଯ୍ୟନ୍ତ ସାକ୍ଷୀ ହେଇନାହାନ୍ତି 17 ଜଣ ୱିଟନେସ୍ ଅଛନ୍ତି none of the person has turned out to be examined right till now and my lord this petitioner was previously on interim bail ରେ ଥିଲା in the meantime my lord he has surrendered on time my lord
Interim bail granted in this case?
my lord
In this case?
interim bail ହେଇଥିଲା ଏଇ case
No, interim bail in this case, there is no, the order sheet doesn't reveal so.
my lord ଏଠି ଅଛି in the last page my lord
Order sheet ରେ କଣ କିଛି ଆସୁନି?
last page is page number 13 subsequently he being released on interim bail and surrender in the court on 19
order ଟା ଦେଖେ ନାଇଁ ଯୋଉଟା ସେ ଦେଲେ ଏଇଖିଣା এটা surrender certificate
କରିକି surrender last
नहीं ठीक है बट एटा ये जो this when did you file this case? There's no endorsement at all and there's no order sheet
filed on my lord 29
defect was removed on 18/6/2024 so this is a fresh application
my lord
so you were granted interim bail in another case. What, Mr. Biswal, you have not read your file.
my lord this is the said as rejection order that is the due to
मुझे जानने आगे से rejection order कौन लिखी चाहिए but my question is you were granted interim bail in another case probably in BLAPL number कितने तो कौन है BLAPL number टा तो लिखाई थी ना
this is 6074
sir 6074 is this case
मतलब previously 2 month interval 10,715/2022 connected to this case my lord
C3 interim bail
आज्ञा 2 month interim bail ଦେଇଥିଲେ BLP
okay
10,700
that is what I'm saying so that is another case but this is a fresh case
my lord this is fresh case is connected with the same matter
sir connected बोले तो मैं बुझुनी ना
my lord I understand my lord
पूरा कंफ्यूजिंग कर रहे
ମୁଁ ଭାବିଲି ବୋଧେ ଆପଣ ଅଲଗା କୋ କେସ୍ ରେ ଦେଇଛନ୍ତି ସେଟା ସେ ଭୁଲ ଲେଖି ଦେଇଛନ୍ତି
नहीं
rejection order ରେ
that you had approached this court and this is as you have started by saying that it is a third journey
my lord
yes what you say
my lord only page 14 देखो page 14 in that अन्य गोटे कोई जाइथिला କିନ୍ତୁ surrender करनी
ଆଉ ଦି ଜଣ ବି absconder ଅଛନ୍ତି
तो interim bail दिया ହେଇଥିଲା କିନ୍ତୁ ଆଉ surrender କଲାନି
ये तो रेगुलर interim bail ଦେଇକି surrender କରିଛି ଏ ପର୍ଯ୍ୟନ୍ତ ସାକ୍ଷୀ କିଛି ହେଇନି
that Jadu Khila has been granted full regular bail
yes sir
ये जाओ interim bail ले जाओ
yes
नहीं interim bail
same footing
what same footing
ସେ ବି ଧରା ହେଇଥିଲା
no ଦୁଇଶହ ସେଟା ଗୋଟେ କେମିତି ହେଇଗଲା
ମୁଁ ବି ଟିକେ ସେ ଓକିଲ ବାବୁ କହୁଛନ୍ତି ସେ କରିପାରିବେନି ମୁଁ କରିଦେବି
ମୁଁ ଟିକେ କହିଦିଏ ଆଜ୍ଞା ସତ କି ମିଛ ସେଟା ଆପଣ ଜାଣିଥିବେ କି ସେମାନେ ଜାଣିଥିବେ ମୁଁ ଜାଣିଛି ନା does this court speak on the competence of lawyers never whoever stands
କିଛି ପାରାମିଟର ବି ତ ନାହିଁ ଜଜ୍ କରିବ ଯେ ଇଏ ଓକିଲ ଭଲ କି ସେ ଓକିଲ
no Mr. Biswal the problem why I am saying so your bail applications were rejected twice so you don't stand on the same footing rejected twice on the ground on merits had it been the first case maybe yes one could have considered granting you parity but this is you have come here for the third time third or fourth probably
then in that case
your name is Sitaram na Mangala Muduli
my lord
Mangala Muduli no third time what as 6/30 of 2022
my lord
which was withdrawn
my lord
and we understand what is the meaning of withdrawal then it is again interim bail it was disposed of correct so this is the third journey
okay
so only interim bail can be granted for 3 months now 4 months yes the petitioner is in custody since 7/10/2021 in connection with such and such This is his third journey to this court. In an earlier application filed by the petitioner, being BLAPL number 107155 of 2022, this court granted him interim bail for a period of 2 months. Stop. The petitioner surrendered to custody in time without misusing his liberty. The Biswal and counsel of the petitioner files, he produces certified copy of the surrender certificate in this regard. Stop. The co-accused Jaddu Khilo has been released on bail, considering the delay in conclusion of trial. Stop. It is submitted that trial has not commenced as yet, and the prosecution and the charge sheet mentions 17 witnesses. Taking into consideration all the above facts, and the fact that taking into consideration all the above facts, I am inclined to take a lenient view. The bail application is disposed of, directing the court below to release the petitioner on interim bail for a period of 4 months.
Deeply placed.
Each day appearance, all that. Yes. Item 45.
Maybe. Here the petitioners are the younger sister-in-law and brother-in-law of the deceased my lord. And a charge sheet has been submitted 498, 306, 304.
Is there is available?
There is not
My
available.
lord, I pay first or second year anticipatory bail, my lord. Similar putting my lord father-in-law and mother-in-law.
You are the husband?
No, my lord. Husband has released on bail.
Then?
I am the younger sister-in-law and brother-in-law.
Then?
Husband was arrested and released on bail. He has annexed the order, my lord.
You are the
Younger brother-in-law and sister-in-law.
Sister-in-law, brother-in-law.
same order.
Item 46. This is my lord. This is second journey.
Yes.
Anticipatory bail.
Because he's from that.
The same circumstances is during investigation. 307 and 313 has been wiped out.
What are the first or second order?
First or second items, second journey setting comes.
Second journey.
The second journey and second anticipatory.
How is it maintainable?
The change circumstances.
Don't change circumstances. After the surrender kariparnanti, time we file a petition for modification, that will be considered. Extending the date. However, fresh application will be maintainable, Mr. Panda?
Some certain offences have been wiped out.
All right. So you file a petition for modification, that will be considered. That will be considered.
Modification.
Sethere modification.
Modification মানে কোন বেল লিদি বলি কোয়া হবে অলরেডি গোটা অর্ডারটা পাস ହେଇଛି না ফার্স্ট আওয়ার সেকেন্ড আওয়ার ହେଇଛି যা ହେଇଛି ଆଉ কোন କରାଯିବ
In the meantime, 307 or 313 wiped out.
so that will be considered by the court. That will be considered. That modification can be issued or part that
That observation can be made in that.
that the observation can be made. Please this matter next week as per. এরকম উইথড্র করবে এখন সেতবে নট প্রেস করবে আর টাকা ফাইল করবে এখন
So item number 40.
40.
This is the second journey of the petition.
Yes.
After charge sheet, the second bail application has been filed. 46 kg 70 gram local boy, man of Semilgoda.
46 kg from the house of the present petitioner.
Give it to already?
Custody
310-23.
310-23.
310-2023. What's the petitioner is in custody? The petitioner is in custody since 310-2023 in connection with such and such case. It is alleged that contraband ganja weighing 46 kg 770 grams was seized from the house of the petitioner.
From the rented house.
Rented house.
From the rented house of the petitioner. He submitted that the petitioner was present at that time.
Yes, ma'am.
Yes, madam.
Stop. we submitted that the contraband the statutory formalities relating to search and seizure were not complied with. Moreover, the mode of payment of the contraband is also doubtful. Further, despite submission of charge sheet, trial has not commenced as yet. Taking into consideration all the above facts, the bail application is allowed, let the petitioner be released.
High level judge.
So the item number 43.
One modification?
My lord, since it is in committed, city case number will be 127 and pending.
You have mentioned it in your IR?
Yes, my lord.
See, number ta mention hoiche?
Yes.
The order be corrected accordingly?
Yes. More भूल देला.
हाँ, ठीक है.
अब सर ये court in session टा कर देलो हलो. London court बिलो अच्छी. Court in session.
Court in session over the matter कर देलो. हाँ. ठीक.
Oblige.
Supplementary list is over. All right.
Weekly list item number 10.
Respondent. 3 दिन 500 सोमवार टू 500 करूची.
काली जाए जीवो तापर सरला. शुक्रवार से
पुडी खाली गात पटे.
नहीं से weekly list अछि तो.
आज्ञा किछ असुविधा नहीं.
Weekly list if the council doesn't appear, I will at least grant him some time opportunity. If it doesn't appear on Friday, काली भीतर appear ना करे वाला.
As your lordship please.
काली series of orders of dismissal will be passed.
As your lordship please. I have no objection.
Item number 12.
Item 12 on behalf of Mr. D.K. Mahapatra. He has filed the affidavit memo stating that respondent number 1 is dead and his legal heirs are already on record.
So no substitution is necessary.
No. His name is only to be deleted.
An affidavit has been filed stating that respondent number 1 expired on 28/3/2009 and his LRs are already on record. As such, there is no necessity of substitution. That's all. Then we'll have to delete probably respondent number 1's name has to be deleted. The name of respondent number 1 be deleted. Because he is represented already.
Item number 25. Item number 26.
The opposite party husband unlucky husband my lord. It is since 3 days already present.
काली जाए तो जीवो.
आइए.
काली जाए जाएगी तो काव जाओ.
Unlucky husband my lord.
Yes.
I am unlucky.
Unlucky husband.
Husband sir. Chalo. I am going live, that is why I am not seeing.
Item number 31. Item number 33.
Yes.
Petitioner filed this case for transfer of a civil proceeding from Lawrence Judge Family Court Cuttack to
The other side is not there. Mr. Bahali has appeared. We'll call it tomorrow.
1 week after. Some instruction. That is the matter now.
2017 कौन instruction? कौन आपने you want it to be transferred from which place to which place?
From Baleswar from Cuttack to Baleswar.
On what ground?
Ground one petitioner is the wife, my lord, and another 3 proceeding is there.
That is one part, but second part there is no interim order. So what is the status of the case now?
That's I have not known.
No, you obtain that. Litigious matter.
2 weeks after.
What date color?
Same the mention. 15th July.
Litigious matter on 15 July. Then counsel for the petitioner shall apprise the court regarding the present status of the case in the court below.
Item number 36.
Tell.
Item number 39.
36, Mr. Ponda was there. Mr. Alok Ponda was there. He was arguing a matter. Acha, how? 30?
Item 39. Item number 40.
item 41, item 42, item 43, item 44, item 45, item number 49, item number 50, item number 53, item 54, item number 55,
Tomorrow again.
item number 58, item number 60,
All 5-year-old matters will go if nobody appears tomorrow.
item number 61, item number 62, item 63, item 65, item 66, item number 68, item number 70,
Yes.
My learned friend is appearing.
Yes,
For
yes.
the husband.
You want the transfer of
My lord,
case from which place to which place?
my lord, from Judge Family Court Keunjhar to the Lawrence Civil Judge Senior Division Karanjia.
Huh? So near, why?
Pakho bata je, but the 498 case is also pending at Karanjia. He is appearing there.
That is
In
pending at Keunjhar. That is pending at Keunjhar. 498 case is pending at Keunjhar. She is pursuing the matter at Keunjhar.
Then?
Keunjhar.
Yes, Mr. Mishra.
My lord.
So why should it be transferred? Had it been a longer place? Yes, I will. So short matter, कौन virtually appear करियो जो दरकार पड़ो कौन?
Sir, virtual appearance पे कोई.
The petitioner is the wife of opposite party and seeks transfer of CP number 133 of 2022 pending in the court of learned Judge Family Court Keunjhar to the court of learned Civil Judge Senior Division Karanjia. Therefore, transfer has been made on the ground that the petitioner is residing at Karanjia.
My lord.
At Karanjia. And it would be difficult on her part to travel to Keunjhar on the dates of posting of the case, as it is at a distance of about 70 kilometers. 70 hours.
70 होगा नहीं.
Prior 70.
50.
55 किलोमीटर.
इतने भी होगा नहीं, बहुत कम. It is further submitted that ये देखो है ना. This is see, prayer has been made at 70 kilometers. है ना. The Mr. Learned Counsel for the petitioner submits that the petitioner has no means to travel to Keunjhar. है ना. पता. The Panikari Learned Counsel appearing for the opposite party husband submits that the petitioner is already pursuing a case filed by her before the Judge Family Court Keunjhar.
No, my lord. That is before pending before SDGM Keunjhar.
Sorry. Before the learned SDGM Keunjhar under section 498A and allied offences. So, after considering these submissions, this court does not find any justified reason to allow the prayer for transfer, as the petitioner wife is already pursuing a case at Keunjhar. Moreover, she can always seek permission of the court to appear through virtual mode. In the above circumstances, I am not inclined to allow the prayer for transfer. Stop. The transfer application stands dismissed. It shall be open to the petitioner to seek permission of the court to appear through virtual mode.
Lordship, one prayer. It is a case of the year 2022.
Expedite kar do.
My friend is also agreeing to that.
considering the submissions. किसी नहीं further the court below shall do well to dispose of the case as early as possible, preferably within a period of 6 months.
Place.
Item 71,
Correct.
item number 75.
Yeah, please, Lordship, will kindly take you tomorrow.
Tomorrow. Let's pass it.
Item 76.
Please, your lordship.
This is
He just.
Order 51 Rule 11
Mile,
for admission.
mile.
All right, 76.
It is good for right interest of the suit land, permanent injunction matter. Yes, confirming judgment matter. Here is the main ground, issue ground, that is the valuation of the suit matter. Your lordship go to the first affiliate court judgment. That is 90, that is 90, the suit number is 90, 125 for 90. So lordship going to the finding, I am going to only finding, so lordship aware of the fact that finding there is the valuation of the suit is 5,000, but 40,000, but in the technique 5,000. Your lordship go to page 7 of the finding. First round, madam. Issue number 1.
Issue number 1.
Madam.
यानी who page? कितने page?
Page 7 of the lower court. Civil judge, senior division, Balang.
ସେଟା କହୁନାହାନ୍ତି ଆପଣ first appellate court କହିଲେ ମୁଁ ସେଟାକୁ ଦେଖୁଛି.
Civil judge, senior division, Balang. Page 7 finding, madam. I am the defendant install civil judge senior.
Whether the plaintiff issue number?
Issue number 1, madam.
Whether the suit is maintainable.
Yes, madam. Accordingly to the defendants, the plaintiff and the cause of action in the file of the suit, the valuation of the suit land is 40,000. But the plaintiff value of the suit is 5,000. So the suit is grossly undervalued. I am the defendant.
I know.
This suit is valuation is the right title interest for the plaintiff over the suit land and for the following injunction against the defendant. As per the section 7 section IV and D of the court fear, the suit declaration with the constitutional relief is to be valued the opinion of the plaintiff. As such, the plaintiff were not required to value of the suit according to the market value of the suit land. Hence, the valuation of suit land is 5,000. By them for the purpose of a declaration and injunction was fair, was considering pleading, I have found that plaintiff had cause of action of the filing of the suit matter. This is the valuation is one. Second was that also the permanent injunction and also the let's go to the my ground. I have taken the ground in the case matter, substantive question of law, and the section 42 of survey and settlements, he had to go to appeal, but the survey he had to go filing the suit matter. The ground E matter. So let's see page 12 of the my plant, and the one first ground is matter. I also
Was there any application filed for correction of ROR?
Yes, my lord, he have filed the correction of ROR. He has.
Thereafter, he has come to the civil court claiming title.
My lord.
So 42 is the bar.
Yes, my lord.
What was the finding of the court below?
Yes.
I mean, trial court?
Yes. Issue number. The PW1, my lord, page 10, disposed that the Ghasi Pradhan had no settlement right over the suit land. His ancestor Pacha Pradhan had acquired the suit land and the other lands. In the settlement of the year 1916, this land has been recorded in the name of the Mucha Pradhan alone. He explained that the son of Mucha Pradhan was illiterate and Ghasi Pradhan was clever, and he was managed the financial and his name of settlement ROR in the year 1936 before independence of the influencing the settlement of authority. His above evidence could not be believed as he had no personal knowledge about the recording of the suit land. And during the old settlement, he started that the land for the wrong declaration of the father and interval of grandmother. He had not taken any step of the things. Besides the different documents are to cover and the Mucha Pradhan, the suit land and the other lands had been recorded the name of Ghasi Pradhan Fokira Pradhan and son of Mutsa Pradhan jointly did the settlement in 1936. The fact of the separate possession of the land of each of the plot after he had been noted in the remark column ROR Exhibit 1. The land belonged to the Bali Pradhan and others of the Pacha Pradhan has recorded the name of the defendants in the correct settlement. So I found the separate possession of the land as mentioned in the ROR in the settlement of year 1936 and has been accepted during the current settlement had been complete in the year 1976, madam. In this contest, the Lawyer Council of the plaintiff offered the decision of the Honorable High Court of Orissa reported, madam. You will receive our the fact that
All right. We'll admit it. Lord Sri Ekanath, Lawyer Counsel for the appellant. Appellants. Appellants. Consider also peruse the improved judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. A
and E.
E, A and E.
E.
Issue notice to the respondents by registered post with AD, returnable within 4 weeks. Requisites be filed within 3 working days. LCR be called for. List this matter. September, October.
Commencing 2nd September.
The list this matter after service of notice.
Item number 79. Item number 80.
Item 80, Your Lordship, I request to pass over for the day, Your Lordship. Lordship, one more request if I may be permitted to see the substantial question of law because it's an old thing. Oblige, Your Lordship.
Item 81.
I'm appellant. I'm ready.
I am for the respondent. Let it become next week. Some
Three matter.
personal difficult. I have not prepared.
Or at least this matter next week as prayed for.
Okay.
Both parties are, Learned Counsel for the parties are requested to come ready for hearing, final hearing.
Item number 83.
I'm there for the respondent.
I request to pass over for the day, Your Lordship. Oblige.
But tomorrow, if nobody appears, beyond 5 years, any matter pending, nobody appears and it has been called out for the entire week, it will go.
Your Lordship.
5 ବର୍ଷ ପୂର୍ବରୁ ଯାହା matter ଅଛି ସବୁ କିଛି ଚାଲିଯିବ ସେଇ ବାଟ. Yes.
85 maybe next week. Next time.
85 ୟା ପରେ କି 85 ଟା ଆର୍ଜନ ହେଇଯାଇଛି. Yesterday Mr. Mahapatra had.
Okay, 7 time.
Item number 92.
ଯିବା ତ ମୁଁ ଡାକି ଦେଇଥିଲା.
Item 93.
Item number 92. Should be possible for the day, Your Lordship.
93.
93. Yes, Mr. Samadra, did you inform Mr. Bhuya?
Yes, I have told justice. Somebody is hanging out always. Today I don't find it.
Again, we'll take up then.
How Kali?
Kali क्या कौन करेगा?
बाहर कोई था वो.
Item 94.
94.
I'm the respondent.
Tomorrow again. It will be called up.
Item 96.
96. 96, my lord, or any other day. Because my senior, Mr. Mahant will argue this case today is not there.
In the day, mane next week as well. This will. Let's just matter in the week commencing 8th July.
Item 98.
98 भी more next week as well. जो कर देती थी कि respondent appeal.
Same. नहीं तो?
ये सारन करे हम वो संगे नहीं बताए.
79. 79, I don't know what happened. 79. Passover reach kali kyo?
Okay. 79, 92.
ସବୁ infructuous matter ଆସୁନାହାନ୍ତି ମାନେ infructuous ହେଇଯାଇଥିବ TRP ଗୁଡା infructuous ହେଇଯାଇଥିବ tell you civil matters 2003 they may not have contacted their clients and all that but 4 ଦିନ ମୁଁ ଡାକିଲା ପରେ ଆଉ ନ ଆସିବେ ମୁଁ କଣ କରିବି ମୋର ବି ତ ପୁଣି ବେଶୀ 5 ଦିନ ଇନଫ୍ୟାକ୍ଟ କାଲିକି ହବ 5 ଦିନ
ମିଳିବ ଯଦି ଆଜି ମିଳିବ